Good afternoon, everybody. I'm Mike Miller. I'm the motion picture director for the IA and also an international vice president. It's great to see a lot of familiar faces and just as great to see folks I haven't had the opportunity or privilege of meeting yet. I appreciate everyone taking time out of their schedule today to take this bargaining class. I think that we have learned that there is nothing more potent or important than an educated membership that understands how things work and what the process is so that we can take that energy and build our collective power in order to negotiate for the most effective collective bargaining agreements that we can. And the only way that happens is with an educated, engaged, and involved membership, and members being willing to take time away from their personal lives and their families to learn about the process and participate in the process is the only way that that's going to happen. So we've created a bargaining class that will walk through the process for how collective bargaining works, how the law works, how our contracts apply, and what the rules of the road are, and then get into some specifics of the relationship between the AMPTP and the IA and how that actual specific bargaining works as well. And the instructor today is the Education Department Director, Pat White. Pat is also the president of Local 764 in New York. And we are in a very unique position of having an instructor who is not only a subject matter expert and a great instructor, but she also lives what she's going to teach. Pat has negotiated countless contracts with the Broadway League and has sat across the table from the AMPTP in many negotiations on behalf of her local 764 as the president. So Pat is one of those rare instructors that has ongoing practical hands-on experience with what she's teaching. So she knows of what she speaks. So I want to take an opportunity as well to thank Pat and the Education Department for creating this. So Pat, thank you. And with that, I'll turn it over to you.
Thank you, Mike, and thank all of you for being here today. I am going to share my screen. I love collective bargaining, even though it's really, really hard. It's how I first got involved in my union, and I've been working, bargaining different contracts on and off from my local and for other IA locals for over 30 years. So hopefully I'll be able to bring some of that to you and you'll start to like it too. It's one of the most important ways you can serve your local union is bargaining the contract. So the objective of this session, you see right there on the screen, and I also want to let you all know that the slides will be available, correct, Marissa, to you?
So I just dropped them in the chat in case anybody wants to print and take notes on them now, but they'll be available for download whenever folks want them.
You can take notes on them, and after the class, you'll have emailed to you a resource that has some of this information. So try to absorb the information rather than just be like taking a million notes. You have your own style, so you know. But the objective is to give you the education and tools you need so that you can participate on the bargaining committee as an engaged participant, not a spectator, because everybody can contribute. All of us know something and none of us know everything. And so you want to be able to bring your knowledge of your craft, your knowledge of your local, and your own just knowledge as a person to negotiations, but you have to do it in an educated way. So that's the real objective of this class. But before we begin, we're talking about the IATSE basic agreement. And throughout this class, I'm going to be giving definitions of what I think are important words. And I don't mean to insult anybody or assume that you don't know what your own agreement is or what a word means, but we all have to be on the same page about this. And so what's the origin of this basic agreement? Why are we all bargaining like this anyway? And of course, the real history of the basic agreement, books have been written. We could go on and on all afternoon. But the first IATSE basic agreement was signed on November 29th, 1926, which was a really, really long time ago. And at that time, the producers and the union signed a two pages. So when you look at it now, remember what it used to be. And it wasn't so much a contract back then. It was just an agreement to sit down and negotiate over wages, benefits, hours, working conditions, and also over grievances at the time. This was a huge breakthrough in Hollywood labor relations, and it was really just in time because if you look at the dates, it was right before talkies came in, and there was going to be a whole new world of workers in our business. If you look at the date 1926, we're going to talk a little later about the National Labor Relations Act, which really gave unions the right to exist and the right to collectively bargain. This agreement is even older than the National Labor Relations Act. And so all of you Hollywood locals have really had union power right from even before the beginning in the prologue phase. So that is the basic agreement. The agenda today is mostly right there, what you see on the screen. We're going to talk about what collective bargaining is and what subjects do we get to bargain over. Can it just be anything? Find out. Then getting the most of this is going to be getting your local ready to negotiate, making the proposals, working as a team with the rest of your bargaining committee and with the larger bargaining committee of all the locals, talking about like various dimensions of bargaining. Reaching an agreement. What happens if you fail to reach an agreement? And then at the end, right, the final wrap up. And we're also going to talk a little bit about your local negotiations, which are a little the same, but really different as well than the negotiations you're in with everybody else. When we approach collective bargaining, we hear a lot about pattern bargaining. And what is pattern bargaining? Right? You can look on the screen, and when you see on the handout, you'll have this definition, right? But it's a collective bargaining technique in which the contract terms and conditions that have been negotiated in one agreement or sometimes for one union are used as a model for the two negotiating parties, like same employer, different union, for another agreement. Or could be that a union tries to use a pattern that they've established with one employer with other employers. And as most of you probably know, this is quite common in our business. The basic agreement that you negotiate is used as a pattern for other negotiations. Not that it's exactly the same, right? But other contracts, you use that as sort of a floor, a template. And when we go to bargain, and much has been written about this, right? The DGA, the writers, the actors, they've come before us. Now, we'll see what happens. But this is what pattern bargaining is. And I will say you can love it, you can hate it. And usually whether you love it or hate it is about if you're on the beneficial end of the pattern. But this originally sort of came about to make sure that no local, from the union side, that no local or union slipped below the others when it became, when it came to wages, benefits, important terms and conditions. And employers use it, because they don't want, they don't want to be paying more than other employers. So that's what pattern bargaining is. That's an official definition. We're not going to talk too much about that in the class, but the questions come up. So there it is. Now, in every negotiation, there are steps. And I want you to look at this wheel because I'll be referring back to it as we go through the presentation. So there are quite a number of steps to the negotiation, and it's cyclic. So right now, if you look at the upper right-hand corner, create a bargaining committee and prepare for negotiations. That's the phase you're in now. You've probably created your committees or nearly created your committees. All of you who are on this Zoom are planning to be on the bargaining committees, I think, and you're getting ready for negotiations. This can vary from local to local, but part of that is the next point, establishing goals. Sometimes when we're preparing for negotiations, I think we miss this important step of establishing goals because you sit down and you just say, well, okay, we want this, we want that. Nothing wrong with this, right? Making a list, we want this, we want this, we want this. But do we have goals? Do we have overarching objectives? If we do, then we want to make sure that our proposals support our goals. So you want to see and want to establish goals and then formulate your proposals. Now, while we're doing this, the other side, the AMPTP, is doing the same thing. They're creating bargaining committees from among their different companies and getting ready to negotiate. I hope they're not doing this today, but they are doing it generally, right? And they establish goals too. They establish goals for the negotiations and they're making their proposals. So both sides are doing these steps in their own different way. Once this happens and we've got the proposals, we're going to talk a lot more about this. Both sides, we come to the table and we review the proposals of the other side. And back and forth over time, it could be a little time or it could be a lot of time, we take steps to reach an agreement. And that could be anything from just plain bargaining to taking actions to going on strike to anything that you can think of, right? But then you take steps, you look at the proposals and you go back and forth and you take steps to reach an agreement. And once you do, then you finalize the agreement. I'm going to talk about those steps. And then it's almost time again. It's almost time again. And we are always in some part of this process. Some of these steps take long times and some of them take short times. But the purpose of me showing it to you in a circle like this instead of just bullets is that it's a continuing process. And we are in a relationship with these employers, like it or not. It's a legal process, but it's unlike other legal processes because if, for example, I was going to buy a house from Marissa, that's a legal process and it's a negotiation too. But once it was over, once we had gone back and forth and decided on the price and the papers were signed and the house was transferred to me, the relationship would be over. It would be my house. This relationship is never over. Our folks are always on the job with these employers. The employers are always in a relationship back and forth with the union. And so as we negotiate the contract, we're also navigating the relationship. And that is important too. So you take that into account. So now you have a lot of background. I know you're thinking, get to the point, Pat, what is collective bargaining? So collective bargaining, I'll go ahead. Collective bargaining is the official legal term for the nationally recognized policy and process to settle labor disputes since 1935. We talk about collective bargaining, and we use the term collective bargaining interchangeably with negotiations. You know, you usually say we're in negotiations, we're negotiating. You don't say we're collectively bargaining very much. There's a little bit of a difference because a negotiation really is a back and forth strategic discussion with the goal of resolving issues in a way that both parties find acceptable. Right? Any negotiation, that's a working definition. The negotiations between the union and the employer is what we refer to as collective bargaining. So in my presentation, we'll use it sort of interchangeably, but that's the difference. Collective bargaining only refers to these negotiations between a union and an employer. And if you look at the top part of that definition, it's strategic. Think about this throughout this presentation and throughout your work in your committees. You want to be strategic, and which is quite important. There's a lot of characteristics of collective bargaining. You see them all here on the screen. It's an economic process, of course, right? Its fundamental purpose is to establish wages, hours, and terms and conditions of employment. If you only remember like one thing from this whole presentation, wages, hours, and terms and conditions of employment. That's what you talk about at the bargaining table. There are other things that we might talk about, but those are the things that the law says we have to negotiate over. It's an educational process, and I think we can sometimes miss out on that aspect of collective bargaining, and it goes beyond you as an individual saying, oh, I just learned so much about the process. I don't mean that necessarily. I mean that each side, when you collectively bargain a contract, learns from the exchange of information that takes place during negotiations. It's a real chance for you to make management aware of the concerns of the employees and union problems. And because you're at the table with folks who aren't day-to-day on set, who don't have day-to-day contact with your workers. And so it's your chance to really describe things more than just give a list of proposals or talk about why you want it changed. And you'll hear about conditions of the company and concerns of the company. And so hopefully your understanding of the industry and the business will deepen, and it's a chance for you to teach them a little about your jobs, your work. I'm going to skip over legal for a minute because that's a biggie, and we'll get to that at the end. It's a psychological process. A psychological process, because collective bargaining, being in negotiations, covers not only what is said, but equally important, what's implied and how things are said. Sometimes the way a proposal is presented can be as important as the contents of a proposal. Style matters sometimes. An important aspect of negotiating, if you want, to get ahead, is you want to try to take into account the fears and needs of the other side. Because part of the psychological process will be changing the attitudes and relationships at the table in a way that benefits you. Remember that wheel. We're in a continuous relationship. So there's a real art to being a skilled negotiator. But of course, it's a power-based process. That's why it's right under economic on the slide. Power is a key aspect of collective bargaining because the results of negotiation can depend on the amount of economic pressure that each side can inflict on the other side. It's a political process. When we do this class in person, I ask the people attending who are in the room, I say, how many of you have local union politics in your local? And everyone sort of laughs, right? Raises their hand. Both management and we in the unions are responsible to the people that we represent. And there is a variety of political pressures on us as we bargain. You know, we want to represent the members well. We want to get people what they want, but sometimes different people want different things. Sometimes we don't know how we're going to get what we want. And so we'll discuss this more later, but there's a variety of political pressures on the bargaining team and the negotiators. It's a continuing process. Just remember what I told you. When the contract's settled, the labor management relationship continues. You never walk away from each other. You have to administer this contract together. And so just remember the cycle. It's an acquisitive process. All that means is that everybody is motivated by their self-interest on each side, and you're out to get as much as you can for your side. There's that aspect to it too, and that's important. That's important. So you look at all of this. There are a lot of characteristics and a lot of factors in play when you collectively bargain a contract. Now, I told, excuse me, I told you that I'd get back to legal. The parties to a contract have to conform to applicable laws, and that requires them to bargain in good faith. And the contract that results is a legal document enforceable by the courts. So where do you find these collective bargaining rules? Sometimes I have members say to me, where does it say that? Where is it written? Where's the law that says that we have to do it this way? So this will be different for really each local, but there's some things in common, right? We want to start with our current contract. So in the current contract, there are legal things, right? That's a legal document about how long that contract goes for. When's the next time we go back to the table? What's the process for renewing? So there are legal points in the current contract. Then all of you have things about contract negotiations to a greater or lesser extent in your own constitution and bylaws. For example, you may have in your constitution and bylaws that the business agent negotiates the contracts, or the executive director, or whoever in your local, that the president appoints the bargaining committee, or in some locals, the bargaining committee is elected. But you need to follow your constitution and bylaws, right? And the international constitution and bylaws as well, right? For example, the international constitution and bylaws is what says that the contract must be ratified by the locals. So there's things in the constitution and bylaws. History. History doesn't necessarily bind you in the same way as your constitution and bylaws, but it binds you as a union rep, I think, in a practical way. If you've always had let anyone who volunteered be on the committee, and now you're going to change that up, like nobody can be on the committee until they've taken a class or whatever. You need to, it's okay to change, and it's good to change if it's a positive change sometimes, but you want to make that known to your members and you want to have a discussion about it because history matters. And when you start bargaining a contract, the goal is to end up with a contract, right? And so you don't want to start off with the members with a bad taste in their mouth. Like, I don't understand why it used to be you could just volunteer and now you have to go to a class and now all these things and I have to go to all these meetings. Pay attention to your own history. And then laws. There are all kinds of laws over time that have been passed and court cases that have been tried over the topic of collective bargaining, federal, state, and local. But we're going to focus mostly today on federal law and specifically on the NLRA, the National Labor Relations Act. And don't faint, because I won't just read laws to you during this class, but I do want you to take a look at this Section 8D of the National Labor Relations Act, because it really lays out, and you can talk when your members say, where does it say this? Where I think it's good to share these kinds of things with the membership. You can share any of this information, of course, from the class. But I'm going to go over this with you because a lot of this we'll be talking about later. The National Labor Relations Act was passed in 1935. The country was just starting to come out of the Depression, and labor unions had been in really pitched and sometimes even bloody battles with employers in all industries, trying to make things better for workers, trying to get a share of profits, trying to just get ahead as workers. And so when Franklin Roosevelt became president and started enacting different reforms that were part of the New Deal, the National Labor Relations Act was part of that. And as a side note, championed by the first Secretary of Labor, Frances Perkins, also the first woman in a presidential cabinet, one of my heroes, Frances Perkins, but wanted to give workers power. So you think about this, the Depression and the National Labor Relations Act is passed. And for the first time, workers have real power to collectively bargain. So Section 8D says, for the purposes of this section, to bargain collectively is, this defines collective bargaining, the performance of the mutual obligation of the employer and the representative of the employees. It's a mutual obligation. Before this, the employers didn't have to sit down with the union at all. They didn't even have to talk to you until the National Labor Relations Act was passed. This made it a mutual obligation. So you got to sit down and you have to talk about this, both sides, right? To meet at reasonable times. Now we can all discuss what reasonable is, right? But to meet at reasonable times and confer in good faith. Confer in good faith. We'll talk more about this too. But it means, and think about it, it's 1935. Workers have no power. This law makes it a mutual obligation to sit down together, but it also says, hey, employer, like you can't just sit down with them. You have to really listen and really be aiming to get to a deal on this. Confer in good faith. Confer in good faith. Later on, in 1947, when the Taft-Hartley Act was passed, all of these obligations were also passed on to the union, right? Obligation to confer in good faith. But so that's the reason for it. And what do we confer about? With respect to wages, hours, and other terms and conditions of employment. Wages, hours, other terms and conditions of employment. The law lays out what we bargain over. And in the ensuing years, right, 90 years almost, since this act was passed, of course, there've been a lot of court cases about what does this mean, other terms and conditions of employment, right? There's been a lot of case law about this. All of you, of course, in your locals have your own labor attorneys, and you can always check it out. We'll talk about subjects of bargaining, wages, hours, and other terms of conditions of employment, right? Or the negotiation of an agreement or any question arising thereunder, and the execution of a written contract. You know, back in the day, there were a lot of handshake agreements. Now, I don't think there would be union negotiating where either side didn't want to write it all down, but that's part of the law, execution of a written contract incorporating any agreement reached if requested by either party But, and here's the kicker, this is my least favorite part of the National Labor Relations Act, Section 8D. Such obligation does not compel either party to agree to a proposal or require the making of a concession. So you're not ever required to agree. Not ever required to agree. But the obligation up above to confer in good faith requires you to try. To try. And that's the thing. That's why you see, even during these long strikes, when are we back at the table? You're not walking, nobody's walking away. You have to confer in good faith. You're not required to agree or not agree on anything, but you need to talk. You need to talk. So it's difficult. So mutual obligation, reasonable times, wages, hours, terms and conditions of employment, good faith bargaining, right? Write it down and keep going. Keep going, even when it looks like nothing's happening. So good faith bargaining. So this is what Section 8D created, the obligation that each party needs to demonstrate a sincere and honest intent to reach a labor agreement and be reasonable in their bargaining positions, tactics, and activities. Of course, like what's reasonable? We'll get into that. Courts have weighed in. So as I told you, the origin was the National Labor Relations Act. It's also called the Wagner Act. That's why it says that on this slide. So if you hear it, you know it's the same. Wagner was the senator who proposed the National Labor Relations Act. So that gave the obligation to employers to bargain at the request of the union. So 1935, when the National Labor Relations Act passed, there was wild union organizing. Lots of organizing, lots of negotiating. Unions were really getting stronger and stronger. And then the next big thing that happens, right, in history here, is World War II. So during World War II, the early 40s, unions kind of stepped back in making these kinds of demands because in the United States, the real effort was to prevail in World War II. So the unions stepped back. When the war ends and all the people who had been fighting the war or working on the war in various capacities come back, there's a lot of union unrest because there had been wage freezes, there had been shortages and things like this. And so the unions are like, come on now, time for big increases, time for big gains for the unions. And there were lots of strikes. There were lots of strikes, railroads, steel, all kinds of strikes. If you're interested in history, this is very interesting. But in some cases, it was really stopping the U.S. economy. And so the Taft-Hartley Act, which was passed in 1947, amended the National Labor Relations Act. And what it really did was it bound unions to the same kinds of constraints as employers. It really made everything back and forth. It created union unfair labor practices. We'll talk about that. It created right to work, the ability for states to become right to work states. And the Taft-Hartley Act was not good for unions, but it happened because unions had become so powerful. And Harry Truman was president at the time. The Taft-Hartley Act passed over his veto. It passed in a bipartisan way. And so there you go. That's a little labor history. The three important laws, just as a side note: National Labor Relations Act 1935, Taft-Hartley Act 1947, Labor Management Reporting and Disclosure Act, for all you secretary treasurers out there, 1959. And so if you know those three laws, you can really hang all your other knowledge of running a union and collective bargaining and all that, member rights, all these things on those things. But here we go. So that's good faith bargaining. Came in the NLRA, extended to us really 1947. So the high points of that: reasonable times, confer in good faith about wages, hours, and terms and conditions of employment. Really remember that. Put the agreement in writing, and no requirement to agree to a proposal or make a concession. None. So that I have given you a lot of laws. Marissa, are there questions in the chat?
Just two that came through that are sort of very similar. I think with the experience of the negotiations this year, two questions that at what point is not agreeing, walking away from the table for a certain amount of time, weeks or months? When and if does that tip into bad faith bargaining?
Oh, well, and that, of course, that's a very interesting question. And some of it is, you know it when you see it. Some of it is two parties at the table really kind of decide. If you're across the table from an employer and accuse them of bad faith bargaining, or they accuse you, then what happens is, I mean, sometimes it's just, you're not bargaining in good faith. Yes, we are, that sort of thing. But if it's serious, then one side will file an unfair labor practice against the other. That hasn't happened in these negotiations, and we're going to talk about unfair labor practices as we go. Like a lot of other sort of things that are hard to quantify, it is you'll know it when you see it sort of thing. And there is a lot of case law about what constitutes bad faith bargaining. We're going to talk about that in the presentation. So Marissa, can we keep going?
Go ahead and keep going.
Okay, so we're trying to bargain in good faith. And don't forget, you're trying to get a deal. Even if you're thinking like, I'm probably not going to get a deal, or I don't like these people, I'm not dying to make it easy for them. Whatever you're thinking, you need to have a contract in the end. You want to have a contract, and you want people to be working, and you want to have a good contract. So there are two real modes of bargaining when we go to the table. Oh, goodness. I'm having trouble moving my slides. There we go. Traditional or adversarial bargaining, which is just what you see and just what you think about when you think about bargaining. Union on one side, managers on the other side, and we're like, we want this, well, we want that. But there's also interest-based bargaining or win-win bargaining. Sometimes if you take a class like at a labor studies school or something, they'll talk about win-win bargaining, which is less common, but we do some of that too. So I'll describe that first. Interest-based bargaining is a collective bargaining approach that's designed to help the two sides build agreements around shared interests, what we would call things that are like industry concerns. And in interest-based bargaining, and you can read all this on the slide, of course, yourself, right? You focus on an underlying industry problem and try to solve it, taking into consideration both sides' needs and wants. But win-win, you could really also call it joint problem solving, because it's intended to just make everything sort of better on a particular issue for everyone. And when you think about win-win and working jointly with the employers, I think for me, the first thought is always like, no, they wouldn't do that with us. But in fact, we have a lot of examples from recent history where we have engaged kind of in win-win bargaining. Equity, diversity, and inclusion matters are a good example because both sides care about it. We don't agree necessarily on what the contract should say about it or how it should be addressed, but we do agree, mostly, that it should be addressed And that's where you take a topic and say, well, we can do win-win bargaining over this. And, maybe then you get into a little like, well, how about this? How about that? How about the other thing? But that's a good example. The COVID protocols, everyone wanted work to resume, but nobody wanted to get sick, especially before vaccination was possible and before people really knew how COVID was passed from one person to another. And so the COVID protocols are another example of win-win bargaining. And everybody brings their own concerns. So, of course, the union's primary concern is keeping people safe and sound, and doing it without making them sacrifice like pay, right, and time. And the employers, of course, are thinking, I want to keep people safe and sound too, but I have to think about how much this is going to cost and what the process is going to be. But everyone has the overarching goal of getting people back to work. And so the COVID protocols, preservation of the benefit plans. So we need the plans, the health plan, the pension plan, any of the retirement plans to stay healthy. We need that as workers because we want to be able to have health insurance. We want to have a pension when we retire. And the employers have an interest in that too, because they're legally obligated to provide insurance benefits, right? That was part of the Affordable Care Act or Obamacare. They have to provide insurance benefits, more or less, and health insurance. And they are legally bound to make certain other kinds of contributions if the pension isn't healthy. And so they care. And of course, we care because if they're dumping money into the pension, there's going to be less for them to give in other areas. So that, and contributions to craft skills and safety training, because people knowing their craft and people being safe on set is important to the employers. So these are some examples of win-win bargaining. So, we've done that from time to time on various points, but we also do plenty of traditional adversarial bargaining where you meet and each side needs and wants something from the other side and you exchange demands and you go back and forth. And in this kind of bargaining, it's very common for the parties to dig into their positions. So with the question about good faith bargaining, digging into your position, right? That's kind of a gray line. But when we bargain, most of our negotiations are a blend of these two styles. And so economic proposals like wage increases, benefit amounts, any kind of expansion of quality of life terms and conditions, things, that might also affect the budget on the employer side, any economic proposals involving like meal penalties, night premiums, anything like that, we have on the table. Usually adversarial bargaining, DEI, any kind of craft training. Sometimes you get further with interest-based approach to those particular proposals. And I would say this is a really unique industry, and the health of the industry, you all see that in California when you go to lobby for tax incentives. We're not bargaining then, but both sides want it, right? Because the health of the industry sometimes is, I think, like a little egg. And so both the employer and the union is aware of the fragility of the little egg that we're holding. We see that now, right? And so this is why sometimes we have a blend of approaches. Now, there's a third kind of bargaining that I hesitate to mention it because we don't do it. And we shouldn't do it, but I want you to know it when you see it. And that's surface bargaining. Surface bargaining is against the law. And surface bargaining, and this starts to get into bad faith bargaining and what happens to you if you're bad faith bargaining. It's the refusal to justify your positions with any kinds of facts or proof. It's like, I'm not going to tell you why we need it. We just need it. Declining to bargain with the committee. So you have to bargain with whoever they send, whoever those employers send over to bargain, and whoever we send too. The other side has to bargain with your committee. Refusal to provide information that's relative to bargaining, or I would say, answer an information request more colloquially. We will talk about this. Part of good faith bargaining, the obligation for good faith bargaining, is to provide information to the other side if they need it to make an informed decision about a proposal, or even sometimes to make an informed proposal. We'll get into that. Engaging in delay techniques. So just looking at the proposals and saying, we'll get back to you on that, or I don't know, or we haven't had time, canceling meetings, any kind of delay techniques, right? Submitting brand new proposals and issues when you're well along in the process. So you're going along, you think you're making progress, you think you're almost done, and then the employer out of left field slaps you with a proposal on a whole new topic. That is considered, then you say, how serious are you about getting a deal? Why wasn't this in your original proposals? We might not have agreed to some of these other things if we knew this is what you really wanted. And it's the same for us. You have to be sure. This is why now, for all of you bargaining committees, we'll talk about this, of how you make your proposals. Try to get the members to tell you what they want, what they really want, and listen, and make sure that in your proposals, you really answer. I know there's a survey out now, and I haven't worked on that at all. Answer. Tell people what you want right at the beginning, because it's a sign of surface bargaining if you just say, oh, and another thing, and another thing, and oh, like you agreed to that proposal, great, now we want more. Don't do that. You can't threaten the continuation of the bargaining process. You can't just be like, if you don't give us this, we're going to leave. You're not supposed to do that. And all of these things are unfair labor practices. Unfair labor practices. But committing any kind of an unfair labor practice, which we'll talk about, can be seen as a sign of surface bargaining. So you don't want to do surface bargaining. And you know what I think? It's not on the slide. I think the worst kind of surface bargaining is when, like, they just listen to you, but they're not really bargaining in good faith, because they're like, yeah, okay, we'll get back to you. And like no real progress like that. It's not good. So we can't do it either, right? Remember the Taft-Hartley Act. So no surface bargaining, but also recognize surface bargaining when you see it in the other side. So there are a lot of sort of steps and formulas and things you have to do. The mechanics of the bargaining, because this is an international contract, are largely taken care of by the international. But because some of you have your own contracts in shops and whatnot, I didn't want to leave this out. So part of the mechanics of bargaining are you have to notify, even though the contract expires on a certain date and everybody knows it, you have to notify the other party and offer to meet and confer. Sometimes this is even in the contract, a deadline by which to notify the other party. But Section 8D of the National Labor Relations Act requires parties to notify each other. And in the private sector, this is most of our contracts in entertainment are private sector contracts. In the private sector, no modification or termination of an existing collective bargaining agreement is permitted unless the party that wants to change it, that wants to negotiate it, notifies the other party within 60 days, at least 60 days prior to the expiration, 60. And within 30 days of that, they need to notify the FMCS, the Federal Mediation and Conciliation Service. This is a federal agency that keeps sort of tabs on union negotiations, all of them. And you have to give notice to the other party, and you have to give notice to the FMCS. For the last year or so, all of the FMCS notifications must be online. And even though this is an international contract, you can go online yourself and take a look. It's a really simple form online to notify the FMCS. Why is this important? It's important because if you don't do this, if the proper notification isn't given, you can't go on strike. So you have to do these notifications. You have to notify the employer and you have to notify the FMCS. I guess I should say you may not go on strike because, you can go on strike. But if you go on strike, everyone can be permanently replaced. So you will hear, if you're doing your own negotiations sometimes from a lawyer, you filed your FMCS notice, right? When did you file your FMCS notice? Because you have to have, right, that 60 days, 30 days. The 60 days is so important. But I'll also tell you, if you missed it, try not to miss it. But if you missed it because you made a mistake or whatever, it was the holidays, just file anyway. Just file it whenever you remember it, because the clock starts ticking when you file. It's not like a train that leaves the station and it's gone. So if you're in the middle of some other negotiation now for your local, right, just remember to file. And the whole reason, right, the FMCS, the Federal Mediation and Conciliation, and why do you have to give notice? Remember, like when this was passed, there were horrible, violent labor battles going on. And the whole purpose of these laws is to try to keep peace between labor and management. Because once you get past your expiration date, usually someone from the FMCS will call both sides and say, how's it going? Is there anything we can do to help? And this is where you'll hear of unions bringing in federal mediators to help, try to get the sides together and come to a deal. These federal mediators come from the Federal Mediation and Conciliation Service. And so this is pretty much what I just said to you. And so you just want to be sure, that you do it. The notice provision in the basic agreement is in Article 1, page 6. Look that up, right? And you can't waive it, can't be waived. So speaking of can't be waived, there are rules about the 3 kinds of subjects that we might discuss in negotiations. And you see it on the slide. Mandatory subjects of bargaining. So you already know this from early this morning. These are the things that you must bargain over if either side wants to. Wages, hours, and terms and conditions of employment. You don't have to, if you don't want to talk about it and neither does the employer, you don't have to talk about it. But if either side wants to discuss a mandatory subject, you have to talk about it and you have to confer in good faith. There are also permissive subjects, and these are things that you may bargain over if both parties agree. The difference between a mandatory subject and a permissive subject is that a permissive subject does not directly affect wages, hours, and terms and conditions of employment. And so it's been deemed to not be covered by that strict dictate of Section 8D of the National Labor Relations Act. So some examples of this are ground rules. You normally have some ground rules for negotiations, but what they are and whether you have them at all is permissive. So both sides have to agree to have ground rules, to bargain over them and what they are. Jobs covered by the agreement. This is a big one. If there is a new craft, or if we've organized a bunch of people, but they're not in the contract, that's a permissive subject. And we can ask. A great example is, I know is the accountants are trying to get recognized, be in the contract, but just because we want them, just because we have them, doesn't mean that the employer has to agree to discuss including them in the agreement. So the jobs covered by the contract, they also can't take jobs out of the contract. So that's permissive unless we agree, unless we talk about it. And the ratification procedures are permissive. You normally would agree that the committee recommends ratification, because why would you negotiate an agreement that you didn't recommend? And if you didn't recommend ratification, why, it just doesn't seem to make sense. So you normally don't, but it's permissive to bargain over that. And then there are unlawful subjects of bargaining, where even if both sides really wanted to, you cannot put these things in a contract or bargain over them. And the best example of this are things that are racist or sexist on their face. And thankfully, I think we don't really see this across the bargaining table. It used to be much more common, especially like different rates for women doing the same work. I don't think it was ever in the basic, but in other agreements, right? Unlawful. If it's against the law, if it violates the National Labor Relations Act or any law, you can't bargain over it. Mandatory, permissive, and unlawful. So here's a list of some mandatory subjects. This isn't an exhaustive list. And you can, if you're making your proposals or if you're ever in bargaining, you can ask your attorney. Sometimes it's a really gray line. And all of these have been fought out in court cases. Because if it's, wages, hours, terms and conditions of employment. But when you look at the list of mandatory subjects, and if you're doing your own work and trying to think about, is this a mandatory subject? The key is, does this affect the people working on the job under the contract right now? Could it affect them? The people working under the contract right now. And if the answer is yes, it's probably a mandatory subject. Some permissive subjects. So these are things that don't affect, remember, the people working under the contract now. So the scope of the bargaining unit and expanding or contracting it, right? Contracting it, I guess, could be arguable, but this is where, right? Why can't we talk about the accountants? Well, they're not in the contract now. That's why it's permissive. Benefits for retirees. This is a big one, and not just for our union, right? But because the courts have said retirees aren't working. They're not working, right? Waiver of past grievances. If you come to the table with grievances, sometimes employers will say, as part of agreeing to this proposal or that proposal, we want you to withdraw the grievance. But that is permissive. You don't have to. Settlement of unfair labor practice charges. If either side's been charged with an unfair labor practice and you're in negotiations, sometimes you can bargain over it or want to bargain over it, or you say, we will withdraw our unfair labor practice if you give us ... But that's permissive. Using the union emblem. So sometimes when scenery is made or equipment is purchased, lighting equipment or something, some unions will have that they can put their emblem on it. Sometimes for costume shops, they can put, literally, right, the union label. That's permissive. And if it's in the contract, taking it out is permissive. I think, I'm pretty sure. And then any internal union matters. So you remember this, and remember this for your local negotiations. You don't have to answer these kinds of questions. Well, how do your officers get elected? What are the dues? What's the process by which people join? Can we see a copy of your bylaws? Any of this kind of stuff is kind of like none of their business. And the laws, you can tell them, especially if it helps move something down the field, or if you're doing some kind of win-win bargaining, maybe you want to tell them. But how your local runs is your business. So if they say something to you like, how long do you think Cameron's going to be president? It's like, we're not here to talk about Cameron. We're here to talk about the contract. So that the recognition clause defining, or sometimes it's called scope, defining who's in the bargaining unit, that's kind of linked to, the scope at the top. That's permissive. And who's on the bargaining team? It's permissive. I don't think it happens in this arena, but sometimes I've seen in other bargaining I've done, I'll give you an example outside of your world. When I do the Metropolitan Opera contract in my local, it's a huge unit, and we have a big costume shop and a big wardrobe department, and we have staff and per diem areas in workforces in both areas. And so management will say, can you try to have people from all areas? And then we say, yes. And we would like managers from production as part of the bargaining committee. That's permissive. And that usually happens ahead of time, but you can do that, but it's permissive. You can always say, like, who's on our committee is our own business. So that's permissive. And then I told you, unlawful, right? Forbidden. So racially or sexually discriminatory things, union security and a right to work state. California is not a right to work state, so you don't have to worry about that. Anything against the law, anything. Hot cargo agreement. I always want to take this off the slide because it's such a long thing, but it's a hot cargo agreement basically is language that prohibits an employer from dealing with other employers during a labor dispute. That's for your future research if you're interested. And a closed shop is just they can't hire anyone who's not a union member. That's closed shop, and you can't bargain for that. So are there any questions, Marissa? We're going to move on to preparing the local, but I think this is a good time for a break.
Yeah, a question came up about the strategy of wording proposals. So they tip toward interest-based bargaining, but I know you're going to get to proposals a little bit more later. So maybe just circle back on that.
I will remember that for that time. So that's good. Now we are going to begin talking about preparing your local for negotiations. The things that we talked about before are really an important framework, and try, to communicate them right to the membership, because like everything, like when we're doing our own work on set, it's important to know the framework, right? And all of those things are the undergirding supports to collective bargaining. So you'll look at your constitution and bylaws when putting together your bargaining committee, just to be sure that what you're doing is kosher, and also respect your local's history. Doesn't mean you can't change things up, but respect your local's history. Don't forget that. And then all of you as the bargaining committee are going to work together with your leaders to get your local ready to negotiate. So there's a process which differs from local to local, but there's some typical steps, right? So for the basic agreement, local committees are formed in each local through whatever your own autonomous process is. So this is why some locals may be bigger than other locals, some smaller, right? I would say when you're forming your bargaining committees, you should have an eye toward making it clear to the folks on the committee that they're going to need to do work and be at a lot of meetings, right? Because the whole purpose of this training is to prepare you to be active participants. Right? You don't just go on the bargaining committee so that you can see what's going on at negotiations. You go on the bargaining committee to participate in negotiations. So you have your own local bargaining committee. And then from that committee, your local recommends representatives to the internationals negotiating committee from among the members of that team. And again, sometimes it's constitutional because it says that some of your officers go, whatever. So this international committee is what I'm going to be referring to as the table team at negotiations. It's frequent when you have a big local or a big contract with a lot of people that you have a table team that's at the negotiations and then a larger bargaining team that's working in other ways, right? Supporting the table team. So there's that. So you recommend to the international president who will be on the table team, and then President Loeb appoints representatives from each local for the IA committee based on those recommendations. And then added to this group from each individual local are lawyers, IA staff, sometimes benefit funds, experts, sometimes others who have knowledge, right? Accountants, maybe sometimes, right? And this group is the table team. And local teams, your own local team, and who the table team is for your local negotiations, that'll be up to you, right? But for the big negotiations, for the whole basic, local teams might be assembling via Zoom for caucuses with the table team, meeting or maybe as a full group, or you may have your own caucuses too, with just your bargaining committees to let them know what's been going on at the negotiating table. So that's kind of what we're doing. So you want to form your committee. That's the first thing. If you remember the wheel, right? You form a bargaining committee. And what's the role of this bargaining committee, the negotiating committee, right? Well, there's a lot. There's a lot. So you're responsible for the negotiation preparations in your local. So within your local, if you're going to do surveys, if there are going to be set visits, and I think in most contracts or most locals, you have field reps or business agents that visit the sets, but all of you hopefully will be back to work soon. Anybody who's working on set can talk to the people that they're working with about the contract. There are membership meetings, and there are other kinds of meetings. You can find out what your members want in many different ways. Many different ways. Now, I'm going to talk to you a little about surveys because I've heard, I think locals and probably some of your locals have sent out surveys in the past. And local unions will say, well, we have, 1,000 members. And we sent out a survey and only 47 people sent the survey back. And if people don't participate in the survey and don't tell us what they want, they can't complain. Well, if you learn anything in this class, please learn that they can complain, they will complain, and they will, because they still want things, whether they tell you in the survey or not. Now, it is incumbent on the members, right, to answer. That's true. But you have to also, as a local, create some other ways for them to tell you what they want. You have to find out what they want. So it's never too early to start doing this, and you should certainly be starting to do it now. You can have stewards help with this. You can give your members within your local time to respond. You can make sure to get people talking about it. Get it in the wind. And I will also say that for membership meetings, this is a big topic, and some locals have really long membership meetings to begin with. And so you may want to have a separate, in my local, we call them open forums or town hall, either on Zoom or in person or both. Some members like Zoom better, some members are better in person. And just have it be a brainstorm. Just have the members tell you what they want. Don't curate it too much. Sometimes member A wants something and member B wants the opposite. Write it down. Part of being on a bargaining committee is knowing that you're not just there for yourself. You're representing everybody. And so you need to listen. You need to listen, and you need to listen more than you talk. And so when somebody tells you they want something, you can't just say, well, that we're never getting that, right? Oh, we're not, or I want that too. You listen, you write it down, you absorb, you learn. You learn. Because remember what I said at the beginning, right? Everyone knows something, but no one knows everything. Don't assume. Don't assume. Okay? So, so you're going to be, as a committee, formulating proposals and strategies. When people tell you what they want, listen and take some notes. Don't just be saying to yourself like, yeah. I know this is what Martha always says to me. Or, oh, yeah, Bob, right? Uh-huh. No, listen, take notes, ask some clarifying questions when people tell you what they want. Say things like, how would that work? That's a great question. Instead of it wouldn't work or we'll never get that, how would that work? How would that work? It's a good one, right? Who would this affect? Things like that. Try, if somebody's talking to you about a proposal and it's quite detailed and it's about something for which they're an expert, right? Maybe they're just even hired for this thing that they're talking to you about. Get them to explain a little. You know, sometimes because we work in such detailed technical crafts, members can really go into the weeds when they're telling you things, which may be really necessary in the end. But in the beginning, you have to try to understand what they're talking about and take their pulse. What are they thinking? You know, what are they thinking? What do they think about working under the last agreement? You know, you have to be really careful that you're bargaining this agreement, not trying to renegotiate the last one. And so you have to, you know, take the pulse, right? And you want to show unity. You want to show unity. And you want to be a team as a bargaining committee. You may have been put on the bargaining committee because you have disagreements with other people on the bargaining committee. And getting together is going to help develop some kind of consensus in the local, but you want to show unity as a team. Where it says be a team player, you don't see in sports teams when a team loses, for example, somebody being interviewed afterwards saying, yeah, I think we would have won this game if Pat had made that catch. No, they don't say that, right? They say things like, well, the other team played hard. And if somebody wins a game because they make a big touchdown or hit a home run or something like that, and they're interviewed afterwards, they're like, yeah, you know, I carry this team on my back. I'm really the hero. They don't do that either. You have to be a team player. You have to be a team player. And recognize that during the term of the agreement, during this last contract, discussions naturally take place between the IA and your local leadership, right? And all of you together too. So about strategy, about focus, these classes, as Vanessa said at the beginning, came out of that partly. So these discussions have taken place. Bear those in mind. You're listening to all of this. You're just listening and taking it all in as a committee. and you're trying to come up with a strategy. You're hearing what the members want. How are you going to get it? How are you going to get it? Your strategy is a plan to achieve a desired outcome or goal. Now, what are your members' main issues? Your members, right? What are your locals' core goals? I find this question really interesting. What are they? Like, uncover them. I mean, you do have like a purpose, right, in your constitution and bylaws, but what are your core goals? What do people want? Why are you at bargaining? You know, sometimes I think we go to bargaining just because it's time. We have to. Here we are. Sometimes we come to bargaining because we really have real questions and concerns and asks. And so what are your locals' core goals? Because this is stuff that you really should consider when you're making the proposals. When you're making the proposals. And when you do this, you have to remember good faith bargaining, because you want to make sure that you bring these things up. That you bring these things up. This is your chance. This is your chance. It doesn't mean you're going to get them. And it doesn't mean that everything's going to be satisfied, right? We know how to do this. This isn't hard. You started to do this when you were a little child and somebody who was taking care of you asked what you wanted for your birthday, right? If you wanted something that you knew was a big deal, you didn't just say, I want it. You'd say, and I've been really good. I've been really good. Like, your strategy to get the thing would be to say, I got all A's, or I've taken care of my little brother, that kind of thing. So you know how to make a strategy. Think about it. Think about it. Because how are we going to decide? Now we have kind of a list, right? How are we going to decide what our proposals will be? So we have our member input, the surveys, town hall meetings. I really recommend these outside of membership meetings. You can bring it up at membership meetings, but to really have the time, have a town hall meeting and work with your own process. But let people talk. Let people, that's the hard, I think that's can be really difficult sometimes. Let people talk, have conversations with workers, the people you are with on your own jobs when you're back at work. If you're full-time officers, have conversations with workers. And not just, you know, the most satisfying conversations, of course, are with people who reinforce what we already believe. Have conversations with people who have different opinions and learn from them too. What are problems that need to be solved? Are there any grievances? Have we had any grievances? What are the problems that need to be solved? Maybe we talk to the leaders of the other locals. If we all have the same concern, then we can go in with that as a general proposal for everyone. Have there been any recent settlements that, you know, have grievances been settled, and how were they settled? And are we satisfied with the way they were settled? Past negotiations. This is really important. Look at what you achieved in the past, where you feel you fell short. Look at your proposals from the last time. And this is in your local negotiations too, right? Because we haven't had local negotiations the last time. So look at your local proposals and look at management's proposals. Because management last time proposed things that maybe they didn't get. And maybe they're going to propose them again. And so you need to be ready for that, right? You want to have your arguments. So look at the past negotiations and how they turned out and what you achieved and what you didn't achieve and what happened with management's proposals. You want to be ready. Because management is doing their version of all of this same thing. All of this same thing. And they're usually doing it to get what they would call production efficiencies, but really just to see where costs can be reduced. So this is, all of these things come into play when we try to decide what our local proposals will be. And then You get together with your local and you discuss and try to understand what your local's top priorities are. You can use, there's a lot of tools to do this. You can just have a meeting and discuss it, right? You can do a SWOT analysis, or have another discussion of the strengths and pitfalls of this proposal. And for anyone who hasn't done a SWOT analysis or doesn't know what it is, SWOT stands for strengths, weaknesses, opportunities, and threats. And we do, on the international website in the education session, have a short, I think it's 25 minutes long, little webinar on how to do a SWOT analysis. So you can take a look at that. You can identify and create any necessary subcommittees. So the one I see most commonly is a safety, like a committee that's going to make a safety proposal. If you have a lot of different crafts in your local, you may want to have subcommittees for the various crafts. It's up to you, but you want to identify and create any necessary subcommittees. And then, of course, right, review other industry negotiations to see where pattern bargaining may be applicable. And we talked about pattern bargaining at the beginning. Even if you can't stand it, you have to know what it is. You have to know what the pattern is. You certainly don't want less than the pattern. And you can't just always look at the wages. You know, was there a percentage or a dollar amount in the wages? You look at the whole package, right? The price of the whole package. And you want to make sure that you know. So, I'm in one of the New York locals. So you're all often setting the pattern for us. Well, good job. That's what I'm saying. So set a good pattern. While you're doing all this and preparing as a team, suggesting that you try to make decisions by consensus. Now, I will tell you, this is difficult. It's certainly not required, but I really recommend it. Consensus, you see this on the screen, right? It's a cooperative process where the whole group develops and agrees to support decisions, for example, what a proposal is, or whether you bring it up at all, in the interest of the whole. Not just the whole committee, the whole local, maybe even the whole industry, a whole union. And in consensus, the input of every person on the committee is considered and their legitimate concerns are addressed. And I would say that this takes a lot of time and it requires a little grace. It requires listening and it requires some give and take on the part of everybody. There could be things, for example, if my main proposal was about overtime, but somebody else's main proposal was perhaps about meals, right? We go back and forth, right? I think the meals are fine the way they are. It's like, I think, if the meal penalties were bigger, we wouldn't have, whatever it is, you go back and forth and you try to reach consensus, try to work together. Benefits are there on the screen. It creates ownership and commitment because once you kind of hammer out a proposal as a group, it's everyone's proposal. It's inclusive, everyone's engaged. It can definitely lead to better quality outcomes because you've almost done a lot of troubleshooting yourselves. When you're doing consensus, for example, if Marissa says something, I can say, Marissa, listen, it sounds expensive this way. What if we put it like this? What if we say it like this, write it like this? That can make the proposal better. She might say, you're right. It's like the same thing, but it sounds better this way, builds trust. And it involves and increases the commitment of the whole team. You have to, and as I say, it takes time because you're trying to ensure that everybody's acknowledged. But when the group works on the proposals, it's a lot more effective. It's a lot more effective. It's more effective even than if you're just taking things off things that your members have said and putting them in. You really want to talk about this. So consensus is really good, but you need to choose alternatives, right? And you don't have to go with consensus, right? So you might want to choose an alternative right off the bat if you feel like there is no common purpose or goal. Maybe the people in the local aren't that aligned. Maybe there's strife or discord, right? No common goal. Maybe the members really aren't willing to, as I say, they still want things, but maybe they're not going to be able to, maybe they just don't want to. Maybe you have a bargaining committee that's like, has a really limited amount of time. And we don't have time to go through each proposal like that, right? Maybe there's just low trust or lack of commitment. Or people are polarized. They really want the opposite. Like if they really want the opposite, you're not going to propose to management A and opposite of A. You're not going to do that. And time is limited. If you can't meet to do this, then somebody's going to have to decide, whoever constitutionally is the lead negotiator, I propose, or if there's some kind of an emergency, especially as you get into bargaining and you're asked, like your team is asked by the table team to approve something or come up with language on something, and there's an emergency, maybe you just, can't do it, right? So it's better, but I will tell you that if you're trying to work by consensus and sometimes you think you might fail, what you want to do is choose the alternative to consensus ahead of time so that it's not a surprise and so that your leadership isn't accused of, changing things up or taking things into their own hand. And some alternatives to consensus, which we've all done these before. You can vote. Majority rules on the committee. So if we're trying to decide if this is a proposal and we can't all agree, we can vote. Or we can say, if we don't all agree, we're not going to make the proposal. That actually puts a little good pressure on the consensus process, because if we can't get to something by consensus, if we can't agree with ourselves, we're not going to propose it. But that's one alternative, or just propose everything. That's another one. That's harder. And especially if proposals contradict each other, you don't want to look foolish at the bargaining table. Or the lead spokesperson can decide. And this is not quite as undemocratic as it sounds, because if you've tried consensus and it's a time-sensitive matter and the committee isn't responding or something like that, someone has to decide. And maybe some version of all of these things, but you should choose an alternative to consensus right? And you should choose it in advance. So you can say, we're going to try to work by consensus, but if we can't, we're going to vote. And if we can't meet, the business representative can decide. That's an example. Or, if we can't meet, we won't make the proposal, or we won't respond, or we'll abstain, whatever it is, right? So you've done this work, and now you're ready to write your local's proposals, finally. So in developing your proposals, right, here are some best practices. You want to use detail-oriented and clear language, not vague language. So you don't want to use language like bad weather. You can, and sometimes when we get to the final contract, maybe that's like that's the best we can do to get like whatever, a grace period for bad weather, or cancellation of calls in certain bad weather things. But maybe we want to say, a weather emergency declared by the city, state, or federal government, or maybe we want to say something more specific, but you want to use detail-oriented and clear versus vague language. You want to address the problems or grievances during the last contract term, because management is probably going to do that too. And it's going to be good for you if you have your idea out there in bargaining. Do you have any specific examples related to your proposals? This is going to make it strong. Sometimes if you don't, like sometimes you have a fine proposal, but it's about something that's never happened, ever. And if you can't give an example of why it's a problem or why it might happen, your proposal will be weak. So see if you have any specific examples related to your proposals. You want to research clauses in other agreements that you might want. And doing that doesn't mean just pluck them out. When you do that, you can look at clauses in other agreements, really recommended, but you need to kind of also look at the whole agreement, because that local or union where you're looking at the clause may have sacrificed for that proposal in a way, or for that clause in a way that you're unwilling to. Just saying. So research means research, but look for clauses in other agreements if you want to, and gather data to support your position. Gather data. So if it's a safety proposal, have there been accidents? Whatever it is, try to gather data to support your positions. Doesn't mean you're going to get it, but all of this strengthens your proposals. And you want to have established goals. Now, as you kind of draft the proposals, and there they are, what's attainable? What do you think is attainable? You will get as many answers to this as you have members on the committee. This is a good question to kind of come up with a consensus around, because how can you tell if your goals are realistic? As a group, you need to have a conversation about this. Do you even agree with each other, right? Come up with this, and also think of alternatives. Thinking of alternatives doesn't mean that you're not pressing for your goal. It means you're prepared. It means you're prepared. Here's our goal, right? Here's what incremental progress looks like. Here's our priority. You just know what the members think, and you know it because you've talked to them and you've hashed this out with each other. Don't make big promises or boasts to the membership. Don't do it. Don't do it. This doesn't mean that you're not telling members what's going on, that you're not discussing the proposals, but don't forget, you're trying to get an agreement. You're working toward ratification, whatever it is. Look at the writers. The writers were out on strike for months and months and months, but at the end, when they had a deal, they wanted the members to ratify it. Because when you're there at the end, talking about the agreement and how you ended up with whatever you have, you want, as a committee member, to be able to honestly say to the rest of the membership, I was on the committee. And if you were there like I was there, you would be saying to everyone too that you should vote to ratify this contract. I really think that with all our hard work, this is the best we can do. And it makes some incremental progress toward our goal, or it achieves 2 of our goals, or whatever it is, right? But you need to be, and to go to the next point, clear on how the release of information is going to be handled, right? And the IA will too, because you want to try to avoid rumors. If there's in an absence, in a vacuum of information, people will just do their best, really, and sometimes kind of make things up. And then things can develop a life of their own. I forget where I read this, so it's not my original thought, but that people don't necessarily believe things because they're true. They believe things because they're interesting. So sometimes some of these things, could be really interesting, but not true at all. So you want to try to avoid rumors and have a plan in mind what progress toward your goals looks like. This is going to help you. None of this is mandatory, but this is a best practice for people who bargain. And, you know, it can really help you in your negotiations. Now, I don't mean to insult anybody by saying understand your proposals. But you do want to look at what the real cost will be to your employers. There are whole classes you can take on costing out a contract. And I think, where that's necessary in the international agreement, the IA will work on this. But think about it, right? Because like $1 in wages isn't $1 to the employer, because they have to pay the benefits on it. They have to pay the unemployment taxes, right? They have to pay Social Security. And so disability insurance. So all of those things. What's the real cost to the employers? And not just in like a wage increase, but like having more people, that would, so just think about it. So, because it's the first thing they're going to say to you when you make your proposal, and you want to know how they're going to be coming at you, right? So that you can fight most effectively for your proposal. Then also really look through, and this is where consensus can really help, right? Will this have an unintended effect on something else in the contract? Hair and makeup and wardrobe don't want to come in until a certain time. What does that do with everybody else, for example? Also, and this goes back to looking at the past negotiations, did you make this proposal before? And what was the result? And was it good? Was it bad? Did you make progress? And also remember, if you made a little progress and they said, we can keep working on this, we can't get all the way this time or something like that, then you want to know that, right? So you can hold them to it. But if you made a proposal and it got nowhere, and you look back and you're like, oh my, we've made this proposal 5 times and we've gotten nowhere, then try to think about other ways to propose it, other ways to word it, new justifications for it, more facts, more research, something. Because otherwise, it taps into Einstein's definition of insanity, right? Doing the same thing over and over and expecting different results. If you've made the proposal before, what was the result? And the reason you want to do all of this is that the employers are going to cost out the proposals, and you just want to have an idea of what they're going to say. Sometimes they cost them out and they're wrong, but you do want to know kind of a ballpark of what the ramifications of your own proposals are. Another thing, once you've made your proposals, you need to prioritize. So what's the most important? And is there one thing when you look at your list that feels like a must for your members? And if not, think about, do they even tell you what their priorities are? Or is every single thing equally important? That is so difficult if members don't prioritize or help you prioritize. And then, but you have to be aware of what's termed here as the squeaky wheel syndrome, because you want to try to bargain for things that benefit a large group of your members instead of things that are only used by a few people who might be very vocal. It doesn't mean that you're not going to try to help small, slivers of your membership or people who are in a very specialized situation. That's not what I'm talking about. Just talking about someone who's always sending you email about stuff, always texting you, always getting up at membership meetings, talking about something where you're kind of wondering if anybody else even, prioritizes that. Beware the squeaky wheel syndrome. How are the benefit funds doing? This is really important after these long strikes. because not only might you want to make proposals, and the IA does usually do a lot of research on how that's going, and many of you have trustees on the plan, but how are they doing? Because if the employer has to divert a lot of resources to the plans, then there probably is going to be less that they're willing to give toward other things. But you need to develop consensus around the priorities, and you need to be prepared to revise them as you go in the face of external pressures. So maybe members change their mind, right? For some good reason, like a pandemic. Or maybe your number one priority is just a non-starter, and you see that when you get there. Maybe you want to reprioritize. But it's really important to think about this. Which are the most important? What are the most important? Another thing to consider when you're making your proposals is that you have the right to make an information request. And if you think back to Section 8D, right, this comes from Section 8D. It's part of the good faith obligation, because if you're bargaining in good faith, you can't be holding all your cards so close to the chest that you don't give important information to the other side. Because it's an international agreement, you coordinate with the international if you want information requests. A good example of this is safety. If the employer made some kind of proposal on safety and said, we've had a lot of accidents, and so we want to do this, you could ask for the accident reports. You can ask for things like payroll reports. You can ask for their policies. A lot of them may have policies on things like respectful workplace or different kinds of policies. If they've done any studies, sometimes they've done, especially now, DEI studies, right? Or time studies. Any correspondence about a specific issue? I think both sides in this, because the international is involved, and some of you are trustees, you have information about the benefit plans. Any kind of time cards or schedules, right? You have the right to this kind of information, but only if it relates to a proposal. Only if it relates to one of your proposals or one of their proposals, or a claim that you make. So when you make an information request, be sure that the timing is strategic. Because if you make an information request, say if you request accident reports, it'll tip the employer off that you're going to have a proposal about safety or accidents or something. You may not care, but just be aware that it happens. And as you're using it strategically as a tactical device, you don't want to weaponize it. You don't want to weaponize it. And one time, I really learned this the hard way, because we made an information request, and really we were just kind of irritated with the employer too. And we wanted to, I don't know, we just were irritated. I'll just say that, leave it at that. Anyway, on a Friday afternoon at the office, in comes a messenger with like 6 banker boxes full of paper. And it's like, what is this? And it's from the employer. It's like, this is your information request. We thought we were getting like a little file in email, or even maybe a little paper file, FedEx. He called up and said, all we wanted was the file about X. The employer's like, it's in there. And then, of course, you have to read everything they send you. And so, and it's like, oh, I didn't feel as smart. But so you want to make sure that you're not weaponizing your right to information requests. And also, the employer can demand to bargain over it. You can demand to bargain over it too if they make an information request of the union. You say, like, why do we need this? What's this about? What's your proposal? So only make information requests relevant to negotiations. And again, because the international coordinates with you, I don't think you'll like make a mistake or run afoul here, but it's good to know. And it's good to know, especially if you have your own negotiations. So anyone who's done this before is familiar with the proposal form that the Motion Picture and Television Department sends out. You don't have to actually look at what this picture of the form says. You'll get a version of it. I just wanted you to see what it looks like. And your local needs to send it back with the proposals. Now, it asks for a lot of information. And in terms of filling out the form, do your best. Just do your best. But don't not send in anything. Even if you only want money, put it on the form and send it to the IA. And in filling out this form, also try to make clear what your local's priorities are. Simple and clear, okay? And don't use vague language. The International doesn't send this form to every member. They only send it to each local. And so you want to really, really try to fill it out, but you don't have to squeeze a big, long explanation into any of these little squares. You can attach pages. That's what I'll say. Just do your best. Just do your best. And I would argue that the committee should, it's up to your own local, but the committee can be involved in this. You can't blame the business agent or who's ever doing these proposals if they're all by themselves, at night, trying to figure out from all these lists and all this work and all these, crew interviews and whatnot, what the proposals are. The committee should have done the work. It should be pretty clear. And then, you can have a subcommittee or something helping with these, but you want to make sure that you submit them, that you should submit them on time, and that they say what you want. And there's nothing wrong with saying, this is our number one proposal in our local, in local 1, 2, 3, whatever your local is. This is our number 2 proposal. And you don't have to number all of them. You can just say, here's the rest of our proposals. But there, okay? So be sure to send in the proposal form. Now, when you're looking at the contract and you're looking on to what we should be making proposals about, you also want to look at the side letters. And side letters, usually called side letters, I think in our world, sometimes they're called side agreements. A side letter is a collective bargaining agreement that's not part of the underlying or primary collective bargaining agreement. Or it could be, right? It's sometimes that, or it could become part of the underlying collective bargaining agreement. We have both, okay? And an example of one that didn't become part of the underlying agreement are the COVID protocols, which sunset. An example of a side letter that is basically part of the underlying collective agreement is the new media agreement. And so we have both. Why do you do a side letter instead of just putting everything into the contract? Is an excellent question, and it's frequently asked, right? So it can be used, right? And you see on this, to reach agreements that aren't covered yet by the contract, and to clarify issues in the CBA, to modify it permanently or temporarily. When you first do it, it's because you don't know if the condition or the thing that you're bargaining over is permanent. And sometimes, as I say, with the new media, it becomes permanent. And then sometimes, like with COVID, thank goodness, it doesn't. We have a lot of side letters now, and we have side letters that detail special conditions for half-hour and 1-hour pilots, 1-hour episodic television series, other than pilots made for basic cable, long-form television, motion pictures made for home video productions, basic cable, right? All of these things in the new media agreement, right? Look at those two. Look at those two. So you want to look at all of those when you're making your proposals, and you can modify them, right? You can modify them in bargaining. So we've done all that. You've sent it in. The IA has met with the table team, and the table team does their version of that. And now we're ready, finally, and we're like 2 hours into this presentation, right? So a lot of the work of the bargaining committee is happening before we even get there, but we're ready to exchange proposals with the AMPTP. And you're going to have two sets of proposals. You're going to have your individual local proposals, then we'll have the group proposals that the table team has, and they get presented to the employer. So normally what happens in our world is that when everything's ready and the IA representatives, President Loeb, Mike Miller, and the representatives from the AMPTP will say, we're ready. And then both sides will exchange proposals, these days electronically. And the table teams will meet to get a first reaction. Why do we do this? To save valuable bargaining table time. We're going to talk about caucuses in our next parts, and we'll be able to use our time effectively, almost have a caucus before we start bargaining, and come up with our first reaction before we go to the bargaining table. So we're ready to come to the table with the AMPTP. And then we're at the table. It really is, when you get there after all of this work, it's like, wow, good, here we are. Now, here we go. And so we're with the AMPTP, and all of us say AMPTP, we kind of know who they are, right? Who is the AMPTP? This is information off their website. You may have your own answer to the question, who is the AMPTP? I leave that to you. But the AMPTP is the motion picture and television industry's official collective bargaining representative. And they negotiate 58 industry-wide collective bargaining agreements on behalf of hundreds of motion picture and television producers. And they bargain with the unions that are listed there on the bottom of the slide. So, which I think a lot of you are familiar with, of course. The exact employers that are covered by your collective bargaining agreement and by the basic agreement is subject to bargaining. And your contract tells you which studios are in the basic agreement or the area standards agreement. Now, the AMPTP does not represent all our employers. So remember that. There are other agreements like the pay TV agreements, the low budget and commercial agreements, right? The commercial agreement with the AICP. So the AMPTP doesn't represent all of them. The IA has contracts with other employers, right? But the basic agreement is often a pattern setter for those other agreements. So we're going to talk a little about you presenting your local's own proposals at local negotiations. And some of the process for your local's negotiations is extremely similar, or maybe even exactly the same as the table team will be doing with President Loeb for the overall basic. But the factors that go into making your local's presentation are seen on the screen. So communication, good communication skills. You're right there at the table trying to get your ideas across. Knowledge of the law and the process. That's why you're here for this, right? You know the rules of the game. Your negotiation skills, and then, of course, preparation. You've gone through all of the steps that we've talked about before. Your preparation should be there, should be good. And if you're the person who's going to be presenting the proposals, you should practice. And if you're not that person, you should offer to help the person practice, to listen and to help them. So the team and the locals lead negotiator. So your team works with the lead negotiator to analyze the agreement, get the proposals, goals, right? And then you're going to bargain in good faith as a local. So there you are. The locals lead negotiator or principal spokesperson, and this is often the business agent, but not always. It depends on your local. You see on the screen, has a lot of responsibility, okay? So it's on you. You're the one who's talking. You're the face of the team at the negotiations. So you want to ensure that the local committee is prepared. So you want to make sure that all the documents, research, and proposals are ready to present. This does not mean that the principal spokesperson, the lead negotiator, does all this work themselves. But it does mean that they check it out. You know, it's like being the crew chief or the head. You don't do everything, but you make sure that everything is done and that everything is in good shape. You negotiate in good faith, of course. You make sure that any administrative tasks about the bargaining are handled efficiently, right? Who's keeping notes? Somebody has to keep notes, and it can't just be the chief spokesperson, because that person is going to have to talk sometimes, and it's hard to talk and take notes at the same time. Who's taking the notes? Who is notifying the committee about meetings and process and proposals and other important matters? This can be delegated, but you need to make sure that the person you delegated it to is doing it. And I would add to this too, like who's in charge of getting info to the members, and what's that process? So the lead negotiator doesn't have to make this all up or do this all themselves. They shouldn't, but they have to make sure it's being done. During negotiations, it's the job of the lead negotiator to remind the team of your strategies and goals and check in with those during bargaining. It's very easy to get lost. It's especially easy to get lost, I think, if the managers are just like a wall of no, or if they say things that you have people on the team have a bad emotional reaction to the way management is talking. It's really hard, and it's part of the lead negotiator's job to keep their cool and remind the team of the strategy and goals and keep pressing on. Keep pressing on. This is the job of the lead negotiator. And President Loeb is the lead negotiator at our basic negotiations. And he does this too. You know, he certainly leans into the team, but this is what he does. So let me just, yes. Okay. So there's an overlap of local negotiations and general negotiations a little bit, but generally, local negotiations precede the general negotiations, with an eye toward the locals having their own negotiations wrapped up before general negotiations begin. So they're trying, I know, in the motion picture department to get as much time as possible for the local negotiations. I don't think it's known yet exactly how much time that will be, but you want to, this is also why prioritizing things is critically important. And you're never going to be, even not at this negotiation, any negotiation, you're not going to have all the time in the world. You want to prioritize with an eye toward having your individual deal in place before the generals begin. If you don't finish during general negotiations, some of your local proposals may be folded in to the general negotiations, which maybe that was part of your strategy all along. maybe not. I don't know. But there you go. The process is the same. This is the wheel we talked about for general negotiations, right? And local negotiations. So it's the same. So it's all happening at the same time. At the bargaining table, I would say you want to, when you're there, whether you're in your local negotiations or whether you're part of the table team at general negotiations, you want to dress professionally. You want to take notes and keep a poker face. Keeping a poker face at all times is very important. Very important. I think I have, yes, okay. First of all, you need to be unified as a team. So you want to just listen. You want to kind of have a neutral face. When the employers say something that's just like enraging or upsetting or even good, like, oh, I like that proposal, you don't want to give it away. You don't want to give it away. You want to keep maximum power for your committee. So you want to keep a poker face. Nobody speaks except the lead negotiator, unless it's planned. Unless it's planned. So you may plan for somebody who's a subject matter expert to make a proposal or to explain a proposal on some detailed matter. I had negotiations at one of the television networks once, and we were trying to get an extra fee for somebody who did alterations of jewelry. Sometimes if a very petite person is wearing a piece of costume jewelry, it looks too big on them if they just put it on. And so for television, you want to make it look better. You want to make it smaller. And so we were trying to get extra money and we had failed one time. And so the next time we had a proposal, similar proposal, but we had the member who did the work come in and show examples. So that was planned. And of course, then that person would speak and we got it, which was good. So having examples and thinking of new ways to make your proposals that went nowhere can work. But you don't speak, you don't react, you don't go like, or, or yay, or anything. You don't do anything. Poker face. No one speaks except the lead negotiator. But you can send notes down the table. And I like it if people are kind of prepared, so you're not like fumbling through a pad or anything. You can send a note to say that we need a caucus. We need to talk. I have information about this, whatever it is. You want to be able to communicate during the bargaining with the league spokesperson, but you don't. And you'll see their side does the exact same thing. And of course, no cell phones, no photos, no recording. That's almost always part of the ground rules. I don't know of a union, not even in the IA, just everywhere. If you record audio or video, it really has a chilling effect on bargaining. People speak less freely if they think they're being recorded. So no recording. And you shouldn't be on your cell phone. You can't be you need to be engaged. And sometimes I'll tell you, sometimes, if a actuary is talking about the benefits and it's 10 o'clock at night, you might be having trouble staying with it. Stay with it. Take notes. Watch. Be actively engaged in bargaining. All right. There's a lot of dimensions to this bargaining. It's not just across the table. Although that, I would call that horizontal bargaining. This is what we think of. This is bargaining. Two sides, back and forth. But there's also the kind of bargaining that you will have already done a lot of as you prepared. And that's intra-organizational bargaining. It's bargaining within the union committee. Let's make this number one. Let's reword this. Let's make a counter. Let's withdraw this proposal. We're not going to withdraw that. That's our number 3 proposal. all of this kind of intra-organizational bargaining. And when you're at the table team and all the locals get together, right? Intra-organizational bargaining, working it out, but you try to work by consensus. You try to get stronger using this process. We do it with, hopefully, with a spirit of win-win with our union kin. But it's crucial to get everyone's perspective and impact on issues and try the best we can to address needs of everyone. So we do this intra-organizational bargaining. And employers do it too, especially in the AMPTP, where they have a whole bunch of different employers. They don't all want the same thing either. And a lot of them don't have poker faces. So if you're really attentive, you'll be able to tell sometimes whose proposal you're hearing. It's interesting. Another dimension is external pressures, and these are real. So on the left side of your screen, so yeah, you'll see from the unions, the members, once you go into bargaining, your members are like, how's it going? Are you done? You didn't give up the thing I wanted, right? What are they saying? What did the other local, like all of this right now with the actors, we support them, but do you think they feel the pressure of everybody hoping that they conclude, with a good deal? Yes. There's a lot of external pressure from the members and from other unions, right? When you're bargaining the basic, do you think the New York locals aren't, oh man, I hope they do, I hope they don't give this up. I hope, right? Yes, other unions, that's real. Teamsters will care what we get, right? In the basic crafts and economic realities. Economic realities in the world, in the business, in town, in California. The employers have these too, and you see them down the other side, other employers. This agreement is a pattern for other employers, and there'll be pressure on that. Other employees, these studios all have other workers, non-union workers, and they, if they get just, right flat out, if they give us a big raise, there are other people who want a big raise. What about that? Upper management. So you see, right, the studio heads coming in to these actor negotiations, right? Upper management. And even beyond that, if a company has stockholders. So there's pressure, and economic realities there too. And they have their own economic realities. I guess so do we. They have the fixed costs and the things that they have to deal with. And we have economic realities like people need to work, people need to eat. And so both sides have this external pressure. So we have, of course, in addition to across the table, right? We have we have different pressures on us. And through this all, you want to remember what we learned about consensus. And it gets harder as the process goes along, and it takes patience. But you want to remember what we learned about consensus. And working as a team. So you need to, throughout this whole process, meet regularly with the local and the IA negotiating committees. You need to recognize the importance of solidarity and sometimes compromise in the interest of solidarity. And that can be controversial, I know, but I think it's the way through. It's the way to get to a deal. You saw this with the writers. They were extremely strong. And in the end, they were in solidarity really partly with the rest of us, right? To get back to work. So you want to do this and you want to craft shared proposals and goals when you work as a team. You're not just there for yourself, which is really important. So you do this right through. You do it as you finalize the proposals for your local. You do it in the group table team negotiations, and you even do it a little as you exchange proposals with the employer. So you want to make sure that you work as a team. So through all of this, right from the very beginning, when you're talking to the members, you need to listen. There are whole courses on really listening. And this slide probably doesn't do the importance of listening really justice, but I didn't want to leave it out. This goes for if you're talking with one person on set about an idea they have about the contract, and it goes for if you're in negotiations at the bargaining table, if you're talking especially, and if you're the lead negotiator for your local, really remember this, maintain eye contact, look at people when you talk to them. Notice their facial expressions. I told you, they don't all have poker faces, and you'll see. Try to avoid distractions. Your phone, really, try not to be on your phone. Try not during the meetings. Try not to be on your phone. Learn to focus on the main points. On the main points. If you can drain the emotion out of the proposals on both sides, maybe you want to put it back in. I'm not saying leave it all out, but and focus on the main points. Demonstrate attention, right? I mean, you can't be dumb, but like nod, you can nod, you can be taking your notes, right? Because you want to listen and then judge. Don't assume you know the end. Listen. Just listen. It's hard. You can practice this. You can practice this and just see how hard it is just in your daily life. Don't rehearse rebuttal. You're going to have a caucus. You're going to have time to respond to the employer. Listen, make sure you really understand, especially in the local negotiations, that you understand what they're saying. Don't just be like, oh, here this comes again. No, listen. Ask questions to clarify. Are you saying this? Especially if you actually don't understand, and try to paraphrase to confirm. It sounds like you're saying ... These are good, and that's a really good one if a member is talking to you about a proposal and you're really not sure. Sounds like you're saying money's not that important to you. Time is more important. Because sometimes the member hasn't even really thought about it. They'd be like, no, money's important too. They're both important. It's like, okay, I didn't hear that. Good. So you know it then. Okay, so you listen. When you review the proposals of the other side, first of all, number one seems self-explanatory, but it isn't. I'm telling you right now, you'll be surprised, especially if you haven't been in bargaining before. Make sure you understand what each proposal means. I've been in bargaining numerous times where we get the proposals, they give us the paper across the table, we go through it, we go to our rooms to caucus, and as the union team starts to talk about it, one of the management proposals, we think it means different things. We read it and people start going, oh yeah, I see why you think that, blah, blah, blah. At that point, don't have a big debate. Ask them to tell you what it means. Because it isn't like your guess is as good as anyone's. They mean something. So ask them to tell what each proposal means. Maybe they're being intentionally ambiguous and you don't want that, right? You want to know what you're going to be agreeing to. So make sure when you're reviewing the proposals that you understand what they mean. And if you're a bargaining committee member, it's incumbent on you to ask, right? I think it's very difficult if you're new and the leadership is like, well, here it is, and blum, 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 and ULP, and this and that, and blah, blah, and using, you can just say, slow down a minute. Does this mean this? Or I don't understand. Can you break that down? Don't be shy. Don't be shy. You're representing the membership. And down the road, if you want to get the contract ratified, you're going to have to describe this to the membership. So just make sure you understand what the proposals mean. And part of that is determine what they really want. Sometimes what they're writing, remember when I said when you make your proposals, make them simple and clear? This is why. What do they really want? What are their interests? Sometimes you'll get from the employer like a whole long rewritten part of the contract. And it's like, oh man, look at it and ask, what do you want? What is this looking to achieve? How does this change things? What would this change? If the union agreed to this, that this is a good proposal, what does this change? Right? So that you can determine their rationale for each proposal. And then if they have a rationale and they have a reason, right? And you don't want to do it, right? Maybe there's another way. Maybe there's a solution. Who knows, right? Even like maybe there's a way, like we could get some money for it, right? We could get another person. Who knows? Are there alternative solutions to the proposals that they've made? This is how you want to review the proposals of the other side and ask curious questions, right? You can always say, how would that work? How would that work? How would that work? Or has this been a problem in the past? When did this happen? When did this happen? If they tell you when it happened on this job and it happened with these two workers or this local, you can check it out. You can call your folks who are on that job and get their version of it, right? If you want to, that's what like researching all that, right? And you can make signals. You can make signals. You don't want to, especially in the early stages, give too much away right away, especially if it's a big proposal that they really want and it's something that you think you might be able to give to get something that you want in your local. Then a good thing to say is, we're not prepared to agree to that right now. That kind of signals like we might be willing to agree to it. You know, if you give us our giant pay raise or something like that, right? We're not prepared to agree with that right now. Is an okay thing to say. When you get their proposals, and really when you get their first response to your proposals, go back and review your goals, right? You will have done this before. How can you tell if your goals are attainable? So you've already sort of talked about this once. Were you right? Like, where are you? Oh, look, we're okay. All right. You know, think of alternatives. Think of alternatives. What if you go to negotiations and it seems great the first day? Still, don't make big promises to the members. This does not show a lack of transparency. This shows good sense, right? You want to tell the members, right? So far, so good. So far, so good. But we're being super cautious. We're being super cautious, right? It isn't that you can tell your members what's going on in negotiations, but the key is you never want to jeopardize negotiations by putting things out there. You're trying to get a deal and you're trying to get the best deal possible. So you want to share as much information as you're able to share without jeopardizing things, right? So you have to know. And it's good if you've decided it, right, in the beginning, how release of information to the members is going to be handled. So review all this. Do we need tweaking? Are we good? Are we on course? Are we adjusting the course? All good. So I'm going to, I think, just tell you that when you've gone to negotiations, I said before, there are usually ground rules. Ground rules are a permissive subject of bargaining. So whether you have them, there will be ground rules on a negotiation this big. What they are is subject to bargaining. And the things that you see here are ground rules that are pretty typical of past bargaining with the AMPTP. And so bargaining point by point means you go through each proposal and you probably maybe will reach agreement on some proposals. And the lawyers on both sides will say, we TA that, tentatively agree to that we have a tentative agreement or a TA, right? But it's not really agreed until the whole thing is agreed. It's like, that's why it's tentative, right? Tentatively agreed. And what we say at the big table is on the record, but sidebars, which we're going to talk about, right, are off the record unless we agree. And we're going to talk more about what sidebars are, right? Negotiations are confined to the bargaining table. So that means that we're not like out there making big statements, right? That we say what we mean to the employers across the table, right? No recording. I talked to you about this before, or capturing sound image, right? Of course you take notes, but recording does really have a chilling effect on free discussion, I would say. Imagine even if you were having a conversation with anybody and they said to you, "Do you mind if I record this?" The whole time, even if you said, "Oh, no, of course, record it," the whole time you'd be aware that it was being recorded and it could adjust what you said. And we want everyone to be able to speak freely at the table, no recording. And then the last point is that neither side will speak to the media, but that both sides can rescind a media blackout. I know that members often feel like this is a bad ground rule and they feel like it is sort of intended to keep members in the dark, which it isn't, because if you go back to number 3, right, the unions can always speak to their members. You can always communicate with your members. In the beginning of the writers' negotiations, they were sharing everything in the media as a tactic, right? And this is another thing about like your goals, your tactics, and reviewing them and revising them if necessary. And then as the strike went on, they said, we're not going to be putting as much out as we did in the past, because it can affect people's ability to bargain and speak freely. And so you always have the right to communicate with your members, but putting things out in the press is a choice. So anyway, members, it isn't about, you have to make sure your members know. A media blackout has nothing to do with us being able to communicate with you. It has to do with us being able to do our job with some kind of sanctity in the bargaining room. So that's what it is. So we're going to talk next about exactly what to expect at general negotiations. But I think before we do that, we will take another 10-minute break so that everybody can just take a pause. So I have that it's 11:34. And so we will be back. Oh, Marissa, first, do we have any questions?
Are a couple of questions. We can do them now or after you get back from the break, whichever you'd prefer.
Let's do them now, then we'll take the break.
What entity adjudicates disputes and contract violations, for example, when the producers repeatedly fail to fulfill clear contract requirements such as skills training? So if they're not meeting a requirement of the contract, what's the method of addressing that?
Right. That's not so much at bargaining. That's you would file a grievance under your local's contract. And so you should talk to your attorney about that. If it persists and it's something where you need to firm up contract language or something like that, then you could make a proposal. But that's in the grievance procedure of your contract.
That topic of grievances, someone asked, is there a strategy in encouraging members or locals to really double down on filing grievances and approaching negotiations? I know for our local, people are scared to file grievances and fear of retaliation, which is obviously a cultural issue, but do grievances back up proposals?
I was going to say yes until the last thing. Grievances don't back up proposals, right? Proposals can come out of grievances. What I would say is you shouldn't be afraid to file a grievance if you have a legitimate issue. If you are the workers don't file the grievance, right? The union files the grievance. Sometimes the union can file a grievance in a way that protects the identity of whoever brought the complaint, especially if it's a what we would call a contract case, right? There are two kinds of grievances, really, contract cases and discipline cases. Discipline cases are if someone's let go or disciplined because of something they did or are accused of doing. But contract cases are, we didn't get our meal penalty calculated properly, or this is, a safety thing, whatever, right? And those grievances, sometimes the union can protect the people from being identified. If the employer is violating the contract, it's appropriate to file a grievance. And the first step of a grievance procedure is usually that the employer and the union meets and discusses it, right? And so that's important. If the grievance is still outstanding at the time that you get to bargaining, you can bargain over the grievance, like throw that into the mix, but bargaining over grievances is permissive. So both sides would have to agree. I have been in situations with certain employers where I didn't have much to give up. And so I was happy to have I wasn't happy to have the grievances, and they weren't filed as a tactic in bargaining. I've not really seen that done, but I was happy to have the grievances because I could sort of use them to bargain away, to get things, bargain away the grievance to get things, but or to solve the grievance, to finally get it solved. I hope that's an answer. This is a really good question, and it's something that you should talk about with your committee and talk about with your lawyer or possibly an IA rep. But the big points are, don't be afraid to file grievances if there are contract violations, or of course, if there's a discipline thing, and don't do it just as a tactic. Don't file frivolous grievances, because don't forget that relationship. Everything you do, your relationship with the employer matters. And having a good relationship with an employer doesn't mean you're like in bed with the employer. I suppose it could, but it mostly means that you can solve problems quickly when a grievance comes up. And a grievance procedure, my last thing on this, because I know people are like, I thought we were going to have a break. The grievance procedure, for the people who are a little hesitant, is what both sides have already agreed to do when you have a disagreement, right? Before the National Labor Relations Act, or if you have no grievance procedure, all you could do was walk out if you were the employees. If you said we're owed an hour of pay and the employer said, too bad, I'm not giving it to you, what were you supposed to do? And so that's why there's a grievance and arbitration procedure in most contracts, is to give an orderly way to solve problems so that, so that you didn't just withhold work. You couldn't, have a strike. There's there are whole classes on striking over a grievance, but that's another day. Don't do that right now. Now,
I would just add, sort of as an additional note to that, Pat, I think while you were talking about sort of info requests and the strategy of info requests and not sort of tipping your hand in some cases, and I would say strategically also like filing a bunch of grievances for the purposes of backing up a proposal is also going to tip your hand to the employers going into negotiations when you might not want to do that. That's sort of a strategy thing at the local as well.
Right. But if they violate the contract, file a grievance. That's what I would say. So on we go. All right. Yes, Marissa, what else?
Two last quick ones. The one that came up earlier, is there strategy and construction of wording a proposal so that they tip towards interest-based bargaining? Like, how would you advise on shaping language to try and move in that direction?
Well, I think that that's a good question too. I think if it's something that you didn't get before, you can think about that, right? Interest-based bargaining is you don't necessarily interest-based bargaining isn't convincing the employer that something you want is in their interest, right? That's sort of like a tactic that we can be using in adversarial bargaining. But what I would say is showing an employer how something that the union wants is actually in the employer's best interest. For example, how doing something in-house or making something in-house is actually cheaper than having it done by an outside third party, right? Like that would show, like, so if you have like this work must be done in-house, that's your proposal, whatever it is, right? Then tipping it toward interest base could be, and look at this, we showed a comparison of this thing being made like by the crew here on the job versus in this place, right? Or whatever, or buying it from wherever, or like just a simple wardrobe thing, right? Like washing and ironing shirts in-house versus sending them out for, is a really simple one. And here's what happens, right? Here's what happens. You can do that. I think talking to your team, sometimes this is where consensus within your own bargaining committee can help. Or to the last point, if you've had a grievance over something and you had a settlement, then working to kind of build on that in your proposal could be good too. I hope that's an answer. I'm glad that I'm getting these strategic questions. Think about being strategic. It's hard. It's really hard. What else, Marissa?
Last question spoke to strategy again, sort of, I think, question to when you're in negotiations, are you able to negotiate like wages and benefits separately, or are the different pieces of the negotiation sort of always going to impact another in the process?
Yes and yes. You probably negotiate both points separately, but every part of negotiations impacts everything else. Every part of it. Everything, even things we think don't cost money, cost them money. That this is really the thing. And they attach, and even if it doesn't cost much, they attach a cost to it. So a vacation day, like adding Juneteenth as a holiday, they're going to see that as a cost item, And with wages and benefits, especially now where, you are definitely going to want to look at the health of the funds, and the international will be really spearheading that for you. But the health of the plans is going to be a real factor. And so how much money goes there is going to affect how much money goes elsewhere, I would expect. So it's always linked together, but that doesn't mean you shouldn't make specific proposals. It does mean that prioritizing is really important for the locals, and is really important for you. And it's also quite difficult, and you need to tell members, but I can tell you, membership is not going to be so interested in the funding requirements for ERISA pension funds, just not happening, right? But I think you can try to give a simple explanation of why it's important, and especially for workers who are younger, right? Why it's a critical thing for the local. And so we had a hard discussion at one point with my local. We were moving from one health plan to another, and having a hard bargaining with ourselves in caucus. And one of the members said, well, really, this health stuff is even more important than wages, because staying alive is the key to everything else. And everybody laughed, right? And that is like, but it did make us go like, okay, yes, all right. So now we've prioritized that, and but you need to do everything. As I say, this is why it can be satisfying, like any hard thing that you do, and many of you do really, amazing things at work. It's all connected. It's all connected, and there's a cost to everything. And really for us, there is too, because you don't take home the hourly rate. You don't take home the meal penalty. You don't take home the health contributions. You take home the whole package. You take home the paycheck in your pocket. And so it's all connected. So now we've covered sort of the process, right? And we're going to talk for people who have not been at bargaining before with the AMPTP, what to expect at negotiations. I can also tell you that it's worthwhile letting your membership know this too, because, sometimes, and I thought this too, really, when I was rank and file in the membership and leaders would talk about bargaining, it's like, well, did you tell them this? Did you tell them that? You can tell them things, but it's quite a formal process. So the more we know and the better prepared we are, the better we'll be able to do. So at the general negotiations, our committee meets as a group with the AMPTP committee, and it's big. So there could be like 60 of us from the IA, right? 60 or even more on one side. And then on the other side is their committee, which is every bit as large, with folks from all the different studios and entities, right? And we're on one side of the table and they're on the other side in a couple rows, right? And the chief spokespeople for each team are front and center at the tables. And so the proposals are exchanged and talked about a little bit and maybe described. And then both sides break out into their individual caucus sessions in separate rooms. And the caucus is when we really talk among ourselves and hammer out what we're going to do, how we're going to respond, if we're going to make counter proposals or anything like that. And caucuses are sometimes long and sometimes short. That first caucus is where we try to at least look at and have an initial reaction to all the proposals. And after that first caucus, the two groups come back together and kind of relay their initial impressions of the proposals to each other. And at that time, you can ask questions of the AMPTP and they can ask questions of us, right? And these are funneled, of course, through the chief spokespeople of each side. And so this process of meeting together and discussing things and then going apart and caucusing repeats through the negotiations. And even, like a caucus could be, say we had negotiations Monday, Tuesday, Wednesday. Thursday, we might decide to have caucus all day on both sides because we had so many things to discuss or a big thing to decide, right? Or a caucus could just be a few minutes, right? A caucus could just be, well, what about 6? It's like, okay, 6. Or no way, 6. And that could be the whole caucus, right? So the caucuses can be really long or short. And during this time at general negotiations, when this is happening and there are caucuses, individual local bargaining committees may be standing by and available to caucus via Zoom with your local's lead negotiators. If the local lead negotiators who are at general negotiations need to bring something back and get an impression of the bargaining committee from your local, that could happen. And that's an example of a time when you'd be maybe put on standby, told like today during the day. I would say if you do that, and especially if you're scheduled all day for negotiations, and this is where, remember, the chief spokesperson could tell someone on the team, look, if it gets to be noon and and the bargaining committees have heard nothing from us, just step out in the hall and text them and say, still working, like, don't worry, we'll get back in touch. Or, we're not going to need you today. We'll let you know after the meeting, what progress has been made, right? You got to keep people, can't just leave people in the dark. That's what I would say. I mean, sometimes nothing's going on or there's nothing to tell, but if they're standing by, they're standing by. So just bear that in mind. So we talked a little about this before. The role of the chief spokesperson is to speak for the team at the table. If you're the chief spokesperson for your local negotiations, think about this too, right? To understand the proposals sufficiently to explain them or delegate to someone who does. So if it's an extremely technical proposal, you might want to delegate it to someone who really understands whatever you're talking about, the generator, the makeup process, the kind of equipment that's being discussed, maybe, right? Or just talk to, the lead spokesperson might just say, you might not need to go into all of that just to make the proposal, but lead spokesperson has to make sure they understand it all and then get input from the team away from the table. My question to the team a lot of times when we first go out into caucus, right? It's like, what do you think? What do you think? And here, right? The lead spokesperson calls the caucuses and the lead person participates in the sidebars. So we're going to talk now about caucuses and sidebars. So calling for a caucus as a general rule only happens as a result of the lead spokesperson calling for one. Because if anybody else does it, someone's sitting like down, a few seats down on the end, it can undermine the lead spokesperson and sort of destroy their flow, destroy the program that they're working on. And again, any kind of crack in the teamwork can have tactical implications. So you don't want anybody else to call a caucus. What you want to do is what I referenced earlier. If you think there needs to be a caucus, if you have information that's really relevant to something that's being said right at that time, or if for any reason, really, just pass a note down the table that says we need a caucus, and the lead spokesperson will find a natural time in their flow to call for the caucus. Because these are the heart of committee work. So in the caucus, you consider proposals. You can modify a position. If they say no to one of your proposals, you can say, well, okay, how about this? How about not 8? How about 6? How about we withdraw number 2, but insist on numbers 1 and 3, right? How about if we take out that sentence they object to, but leave the rest of the proposal? Those kinds of things. You do that with their proposals too. We wouldn't mind doing this, but we're going to need to get paid for it. We're going to add a sentence at the end, something like that. It allows each side, right, to discuss the issues, like to talk among yourselves, really, and get necessary information. If the employers made some kind of a proposal about all the accidents that had happened at this show, that show, and the other show, and you didn't even know about it, you might want to call your people who had worked on this show, that show, and the other show and say, did you hear of this? Why didn't you call the union? What's up? Right? That kind of information. Or if you have need information about benefits, payroll, anything you need from them, right? Any kind of information requests are best made in writing, but you can make them verbally across the table. So if the union asks for something and it's not a big, difficult, hard thing, maybe, the employer just get the information, or maybe you get the information. Especially if it's easy or something you have. How many of your members are OSHA certified? I'll find out. Right? You can plan strategies and tactics. This is where you can check in with your goals too, check in with your priorities, right? You can iron out differences and between yourselves and address questions. So you may have been having difficulty getting to consensus on something, say over whether like proposal A or proposal B is the most important. And when the employers respond, you can see we have no chance of A, but we have a good chance of B. So even though my proposal was A, the one and Marissa really wanted B, I could see that we should go hard on B because, you know, we won't withdraw A yet, but I can see we have a better chance of B. And sometimes that just irons out differences, right? You can draft proposals and offers. Now, again, this does not mean, remember, bargaining in good faith. This doesn't mean like, you know what we forgot to ask for? This whole other thing. Or, you know, oh, look, they said yes to this. We should have asked for more. That kind of stuff. It isn't that. But you can make proposals, pretend you didn't make any proposals on diversity, equity, and inclusion, but the employer did. Then you could make your own proposal then. Or if you've had a grievance and you won, you might not want to make any proposal. You had a grievance or an arbitration. We had a grievance or an arbitration and we won and we're happy with that. And it means what we said it meant. The employer might have a proposal on that. And if it's the other way around, we might have a proposal on that. You can estimate what things cost. You know, what are they asking us? You can get approvals. And sometimes it's just a relief from tension. Sometimes it's hard in the room and people are testy with each other and the lead negotiators are going hard at it. And sometimes it's like, you know what, we need a break. Or sometimes the other side says something and it just makes you so mad, you know, it's like, we're stepping out now. You know, we'll be back. When you're in caucus, compromising gets a bad name, but compromising is part of bargaining in good faith sometimes, but you never compromise without trying to get something in return and without trying to get as much in return as you can. Compromising and withdrawing proposals is a necessary part of negotiations. Now, when you make proposals, it's usually asking for things that you don't have yet or asking for increases. I need you to remember that when you're making proposals, pretend you have 10 proposals and we've been bargaining along and we still have 5 of them on the table, but 5 of them we've withdrawn as time has gone by for whatever reason. You can't think we've given those 5 things up. Those were 5 things that we wanted and we didn't have, and we still don't have them, but we didn't give up the things. We still hope to get them someday, perhaps. We withdrew the proposal. When you give something up, it means you have something. It's already written into the contract, and the employer proposes that it's taken out or reduced. That's what giving up is, right? That's what giving up. So compromising and withdrawing proposals is part of bargaining, right? Making concessions, which is number 2, right, is like giving something away that you have or modifying something or conceding their point on something. And so that you need to have a reason for when you do it. You're getting something that's really valuable in return, more valuable in return. And you never make a concession without consideration or a caucus, a long discussion just to make sure. And don't make them too fast. Don't make them too fast. Save it for last, especially if you know it's the employer's main priority. And you'll see they do this with us. Don't give it away, especially if in your local negotiations, if you don't have much to give away and it's all they want, you know, as much as you can. Always try to get something in return. It's great if you don't have to compromise, right? But when you do have to compromise, recognize it's part of the process. It's part of the process. And just be sure that you're thoughtful about it and that you keep your goals in mind and your members' priorities too. Your members' priorities. So caucuses, that's caucuses. We want to talk about sidebars too. So a sidebar, a caucus is when our whole team goes off to have a discussion among ourselves. A sidebar is when our lead negotiator, along with maybe, I don't know, 1 to 3 other people, go and meet on the side with management's lead negotiator and a few people to have an off the record conversation. Now, off the record isn't secret. Off the record is just what it says. It's not written down. It's not on the record. And you saw in the ground rules I showed you, this was one of the ground rules. The lead negotiator, and President Loeb is pretty good at this. If you're the lead negotiator for your local, then you need to know this too. You always tell the team everything that's discussed in sidebar, everything. The reason for sidebars, and you can see some of them on the screen, is you want to be able to kind of float an idea or deliver bad news. And bad news, I suppose, is relative. You want your lead negotiator to be able to go out and say off the record, right? Because you're bargaining in good faith, right? You're bargaining in good faith, but you want your lead negotiator to say, listen, number 4 is part of a deal. It's part of any deal we can make, right? And you want them to be able to say it strongly. You want to be able to say, look, 2% is not going to get us there on this. But I don't know, like, how high can you go up? You know, maybe the other person says, we can't say. It's like, well, you're going to have to go up higher than that. And then they come back to the room and say, we told them number 4 has to be in. And we told them 2% wasn't going to go. Stuff like that. It happens, right? And you can see on the list here, they're like offstage conversations. They're just, they happen a lot. They happen especially back and forth as the final bits of an agreement fall into place. Sometimes the lead negotiators need to level with each other or float an idea out. And I think if we didn't do some of these sidebars, the union would be worse off for it. I did assist a local one time, and they would not agree to sidebars in their ground rules. They didn't want to have sidebars, and they wanted the whole committee to see everything. But as negotiations progressed, their own lawyer saw and the committee saw that sidebars would move things along. And in that case, their lawyer was being their lead spokesperson, and along with the business agent, and they did go to sidebars, and the committee saw, they were like, yeah, go, you know. And there has to be trust too, that you're going to hear everything that went on in the sidebar, but it's a necessary part of negotiations. I want to remind you, because we talked about this hours ago, as you bargain, this is going to come up. Sometimes you might hear from the employer, that's permissive, you know. That's not permissive, and on we go. But remember the three kinds of subjects of bargaining. So you want to have this in mind. Wages, hours, and terms and conditions of employment, right? That's the heart of it all. You want to remember good faith bargaining. Good faith bargaining. A sincere and honest attempt to reach a deal. Now, we did have this question, and whoever asked it, I'm sorry, you probably didn't think you'd have to wait hours to get the answer, but how do we know bad faith bargaining? Well, here we go. Unilateral changes. That means we're in the middle of bargaining and the employer just starts changing stuff in the contract. If the contract expires while we're bargaining, the employer legally still has to go by it. But if they just start changing it, especially if they just start changing it to stuff that they're proposing, that's bad faith bargaining. Dilatory tactics. I love this word. Dilatory tactics is like dragging things out. Fooling around, lateness, missing meetings, Making you go over the same point over and over again is a popular dilatory tactic. Failure to respond to the union's proposals. Oh, we need more time to study that. Well, okay, fair enough, maybe on the first pass, but then come on, respond. Respond. We need to give the other side time because you don't want them to necessarily just say no, but they need to respond. Lack of bargaining authority. Are they sending someone to the table that has the power to make the deal? So think about this in your local negotiations, right? Who's ever there needs to have the authority to make the deal. The lead spokesperson in the bargaining team. President Loeb obviously has the power with our group to make the deal. Regressive bargaining. So this is both like agreeing to something, like if you agree like to 3, and then management says, oh, we agreed to 3 yesterday, but coming back, we don't want 3. We only want 2.5. That's regressive bargaining. Or if you agree to 3 and the union says, we agreed to 3 yesterday, now we want 4. Well, that's regressive bargaining. You don't want to do that. Now, regressive bargaining does differ from making a counter proposal, right? Making a counter proposal is when you're still back and forth bargaining, but regressive bargaining is kind of something's decided, right? Or you're working off a set of assumptions and then you change it up. You can't do that. You shouldn't do that. You can do it. You shouldn't do it. Significant new proposals at an advanced stage of negotiations. We've talked about that. These can all be seen as evidence of bad faith bargaining. Bad faith bargaining exposes the party that engages with us, either the union or management, in the possibility of an unfair labor practice charge from the other side. And so this is what happens to you if you do bad faith bargaining, right? The other side can file an unfair labor practice. Bad faith bargaining can be difficult to prove. So remember this slide. I showed you this before. These are all any kind of surface bargaining, refusing to justify your positions, declining to bargain with the committee, refusal to give information when you make a proper information request, delay techniques, putting in new proposals at an advanced stage, threatening the continuation of the process. This is another good use of sidebars, by the way, because in a sidebar, the lead negotiators can say, if you keep insisting on this, I don't know what we've even got for you, but then you're not really at the table threatening the continuation of the negotiation process. You're just telling the truth to the lead negotiator. It's different, right? So any kind of unfair labor practices, those could all be considered unfair labor practices. There are also things called per se violations. Per se is a legal term that means on its face. So if you want to, say dilatory tactics, you're going to have to prove, like if you file an unfair labor practice charge, you go before an administrative law judge at the National Labor Relations Board, and they say, well, what evidence do you have? And then you say, well, they canceled these meetings. They asked us to explain this proposal over and over again. Per se violations are just if they did them, it's an unfair labor practice. If they make a unilateral change to the existing terms and conditions, they can't do that. You have to bargain it. If they refuse to meet at all, like if they just say, we're never meeting with you, that's right. Refusal to give you relevant information. Now they can bargain over information requests, but if they just refuse to give it to you, that's a per se violation, unfair labor practice charge. Refusal to execute a written agreement. Remember, Section 8D says they have to. That's just a pure violation of the law. Direct dealing. Direct dealing. So if they bypass the committee and the lead spokesperson and go right to the members, that could be a per se violation. Or insisting on a point of impasse to on a permissive subject. So We'll talk about impasse in a moment, in a short moment too. But you can bargain to impasse on mandatory subjects, but insisting to the point of impasse on a permissive subject is a per se violation of, and they can file an unfair labor practice, or we can file an, depending on who commits it. Now, what is impasse? We hear this term thrown around, and I want to tell you, don't throw it around. In fact, stop saying it, really. Impasse is when the bargaining parties are so far apart that they can't reach an agreement. They can't even see it. You can't be at impasse unless you've engaged in good faith bargaining first. That's like a requirement of it, right? And that's what objective standard means. Because if you're at impasse and there's any question about if you're at impasse, some of the questions, someone at objective standard, the NLRB, National Labor Relations Board, would look at the bargaining history, whether there had been good faith. How long have you been negotiating? If you'd only been negotiating like a week, how could you be at impasse, right? The importance of the issues on which there is disagreement. So on some minor thing, probably you can't reach impasse. The understanding of the parties as to the status of negotiations. So if one side says we're at impasse and the other side says we're not at impasse, and it's like, oh yeah, it's like, no, we're going to have a new proposal on that right away. We're going to keep bargaining, right? So there is an objective standard, right? The reason we don't ever want to say impasse or say that we're at impasse or threaten impasse is that if you're really at impasse, it permits implementation of the final employer proposal or part of it. They can just do it. They can just do it. Now, it's not impasse if the employer insists on a non-mandatory subject, but the union would have to object. But this is why, even when things get really sticky, you don't hear the I word. You never heard it with the writers. You don't hear it with the actors. I mean, from any credible person who knows what's going on. You didn't hear it from the UAW. It's not a good word for the unions. When I described Section 8D to you, we talked about how the law doesn't say that you have to reach an agreement. But in the end, the world doesn't end, the work doesn't end, and there will be a contract and there will be an agreement. And so what you want to do is keep bargaining. Keep bargaining. Impasse, I would say, is a tool that really only benefits the employer, myself. So if we're not going to say the I word, what happens if we fail to reach an agreement? What happens if in our hearts we do think like, oh, I don't know if we're going to reach an agreement? Well, if you fail to reach an agreement, these are the things that I think could happen, right? The bargaining committee could call for a strike authorization vote if you're not going to reach a deal. Some unions do this beforehand when they go into bargaining. This is a strategic decision, right? But say you haven't done that, then if you haven't reached an agreement, you can call for a strike authorization vote. And that can be used, like if the employers see that that's credible, then that can also help move things along. You can, and after that, right, you can call for a strike. You can call for a strike. Meanwhile, the employers can lock out the union. We'll talk about what a lockout is. You cannot have an agreement and everybody can just keep working away under the old agreement. Sometimes you can do that for a short time and just, it's like a cooling off period. But you can just keep working under the old agreement. You can keep working, and then at some point, the management can implement their final offer, what was on the table. They can't just make up a new thing, but they can implement what was on the table if they're an impasse. You know, the workers can stay on the job and take sporadic job actions. They can, you know, have slowdowns. They can, you know, anything from really like just wearing a t-shirt to kind of to like short job actions. And the parties can agree to interest arbitration, which is rare in our business. But remember, I told you the FMCS supplies mediators. They're not the only organization, you know, whatever mediator the two sides agree to. So these are the things that can happen if you don't reach an agreement. And I want to note that all of these things, even though they're all quite serious and many of them are quite unpleasant, they're all about getting to an agreement. The whole thing is about getting to an agreement. So remember that. So it's important to know, you know, what these words mean. A strike, we know what that means, right? Is that the union stops working and sets up picket lines. And the employer may or may not stop work. So if you go on strike, these strikes we've had, the employer shut down. The employer can try to continue, depending on the strike, can try to continue. A lockout, the company doesn't permit the union employees to work. So most of the time, if we're locked out, we picket. And so for that reason, I think lockouts are often mischaracterized as strikes because to the naked eye from the street, people are walking around with signs in front of the employer's premises. So it looks the same as a strike, but it's different because the strike is called by the union. And when the union strikes over wages, hours, and other conditions of work, right? That's an economic strike. We can be permanently replaced by the employer. Legally, I'm talking about. We can be permanently replaced. If we strike over unfair labor practices, for example, maybe we go on strike because they're not bargaining with us in good faith, right? Maybe they've committed some of those per se violations, right? On an unfair labor practice strike, the workers can only be temporarily replaced. So there's different kinds of strikes. And sometimes, even though you feel like, well, and you know what the remedy of an unfair labor practice is really like they're told by whoever commits it is told to stop by the NLRB. There can be more things, but the real thing is in a ULP strike, the workers are a little more protected. They can't be permanently replaced. A lockout, again, they can lock out the union and still try to keep going. And these are really, really difficult situations. But there's never a strike. There shouldn't be a strike or lockout until the contract has expired. And you do not need to be an impasse to go on strike, and you don't need to be an impasse for the employers to lock us out. They don't need to declare impasse. So these are the differences. So there are costs, right, to disagreement. So you can see on this slide the potential costs to the union. If we don't agree, then there's a strike or a lockout and lost income, right? Could be lost jobs. The benefit plans could suffer. Shows could move permanently, other places, Australia or someplace like that, right? And there could be public image damage, although right now, like the public is highly approving of unions. And then some of the same costs apply to the employer. So obviously strike, lockout, right? Whoever calls it, this is what I want to say. And even if you consider yourself the winner, there's always damage. There's always damage. We see this now, right? Even if you are kind of like the prevailing group, it's a war. It's a war. And a strike is kind of a failure. A lockout, I can't comment. I don't know why they would lock us up, but a strike is a failure because you tried, right? You had your whole bargaining strategy, and this is the last resort, right? But there's damage on both sides. In a war, both sides bleed. And there are also third parties like us right now in these strikes that get hurt. So there's cost to the employer and there's cost to the union. The employer has a lot of fixed costs that they have liabilities for. Of course, they lose revenue. I told you before, the employers have an interest in the benefit plans being healthy, right? These employers, the AMPTP, have competition for market share too. So, you know, not just looking for shows that are, imported from overseas being put on, and they can have public image damage too. So that cuts both ways. A lot of these things cut both ways. So there's a big cost to disagreement. So, it's in both sides' interest to try to make this work somehow and to keep talking. Strikes happen for a variety of reasons. There can be a high degree of hostility between the two groups. So it's really hard to even talk and bargain because there's a high degree of hostility. It can just happen as a pattern breaker. I think we saw this with the writers, right? Just a pattern breaker. Or on matters of principle. There could be no desire to settle. I would say that's more on the employer side. As long as we keep bargaining, we don't have to give them a raise. Because by the way, when you go past the expiration date, don't forget to bargain over retroactivity. You don't have to have retroactivity, of course, if the contract hasn't expired, because the new contract will just go into effect. But if you've gone past the expiration date, retroactivity, you have to bargain over. And sometimes employers are like, I don't care. When this changes, we're going to give them, and sometimes unions, not in this, but they have if there are big pay cuts on the table or something like that, they have no desire to settle, because when they make the deal, then it's going to be a worse deal. Overcommitment. This is where I said, don't make big boasts or promises to the membership, right? And then if you can't deliver, you might be sort of pushed back into the corner of the members wanting you to take a strike vote. Internal conflicts in the companies or internal conflicts with us, where it's hard to get any kind of real forward motion toward making a deal. Maybe the result requires a strike. I think that with the UAW strike you're seeing, they felt that the result required a strike, and or unrealistic expectations on both sides. The employers can expect unrealistic things, and the union can be holding to proposals that are unrealistic. This is general. This is really about all negotiations, but strikes happen for a lot of different reasons. So that the possible results of a strike, and I put the first one, the one we always want when we go out on strike, that the employer increases the package and the workers come back with more. That's like the best possible result for the union, right? The second thing that can happen is that the workers can go back to work for the same package they initially rejected. And this can happen if there's a lot of precariousness about the worker's own financial situation. And, you never want to go out without a plan to get back in. And you need to kind of know how long you think your members are willing to stay out. And if you think that your members, might start to really want to go back to work or really be susceptible to offers to cross a picket line, then, but it can happen that the people that you go back to work for the same package you initially rejected. I have seen that happen. Not in this business, but I've seen it happen in staged locals. I've also sadly seen it happen that the employer decreases the package. That the two groups, the union's out, it goes on and on and on. You finally go back to the bargaining table and the employer decreases the package that was on the table. And by this time, the union is worn out with the strike and the workers want to go back to work. All this has to get voted on by the membership, right? So you can see if any of these things happen, it's very serious. But the workers go back for less. Yeah, you don't recover fast from that. And the relationship doesn't recover that wheel for a long time. Jobs can be lost. Jobs can be lost. If it's an economic strike, the employer can hire permanent replacements. The employer loses business almost always. And the relationship suffers for years. There are hard feelings. When these things happen. So we hope for number one, but I didn't want to I wanted to tell you this. The employer has the legal right to lock you out, but only for economic purposes, only if everyone's locked out. So they can't lock out one, you're all in the bargaining unit, all your locals, so they can't just lock out one local and not all the others. They can only, in a lockout, hire temporary, not permanent replacements. And they don't need to declare impasse before a lockout. So they have the right to lock you out, but it's kind of a limited thing. So even when all of these things are happening, even if there's a strike or a lockout, right? The jobs are there. We're going to need to go back to work at some point. So you want to remember good faith bargaining. It's not hard when you think about all this to have a sincere and honest attempt to reach an agreement, right? Remember, it doesn't mean that you have to say yes to anything, but it means that you have to want to reach an agreement. And you want to try to think about consensus again and again, if you can. But somehow, whether it's been a smooth negotiation of a few weeks or a horrible, long pitched battle with strikes or lockouts or whatever, right? Eventually we reach a deal. And so once we do, it's a wrap-up process. Once you've got the deal, then you want to sign off on language, any little things, right? Dates. Sometimes you get, they say yes to a proposal, but it doesn't become effective until the contract is ratified, or maybe certain things don't become effective until year 2, and you want to look up when year 2 actually starts, right? When the first pay period would be, something like that. You announce the settlement at the table. So somebody usually leading, I think we have a tentative agreement. You consider whether the committee recommends or just takes back for a vote. And what I would say is, usually with us, it's a ground rule that the committee will recommend ratification. If you just took it back for a vote, I would say that unions would never vote yes. If you just took it back for a vote and you thought, oh, I'm going to get more each time we come back. No, I think it's usually a ground rule that you recommend ratification as the committee. And then you address getting the summary out to union members and supervisors, and getting materials so that the members can understand the deal, whatever your process is in your local, having a town hall or a meeting. And then you schedule ratification. And ratification is folks vote folks vote yes or no, up or down on the contract, because once that all happens, at this point, from the union's perspective, the deal is in the hands of the workers. And they're presented with the new contract that doesn't go into effect until they vote to ratify it. And it's been ratified digitally in the past, and it was done by mail. It's a good idea to have information sessions about the contract. If the majority votes yes, right, it's in. No, on we go. And in this agreement, we use, as most of you know, an electoral college system of voting. And I know that there's controversy about having an electoral college system of voting, which of course I understand. It's designed to be representative and balanced, and it's designed so that the concerns of every local and all the people in all the crafts can be heard and brought to the table. Without an electoral college system of voting for ratifying the contract, the tendency would be for the contract to cater more toward the bigger locals with more members, rather than a contract that's fair and considers all the members of the IA. And so just like the electoral college system electing in the US government, this is meant for everybody to have a voice, but also for the concerns of all the locals, depending. If you're from a huge local, you're probably not going to like this. But if you're from a local that's smaller, think about it, right? Even the concerns of your members could not even matter in the voting for the contract if you were, much smaller. So that's the reason for it. And I want you to know the reason, but it's a controversy. It's certainly a controversy in our union. So I wanted everybody to know, as we're sort of getting to the end, just like at the beginning, what important words mean and the reason for things. So we get there in the aftermath of the negotiations, right? Everything is proofread carefully. This will be sent back to your local. So you want to proofread the memorandum of agreement, right? MOA, we say, and that's going to be what's changed, right? What's been changed. And then later, the collective bargaining agreement, proofread it, right? Discuss any implementation issues or problems that there might be with the new agreement. And again, like dates and this kind of stuff. And then give out the collective, once we're done and it's voted on and all that's done, then we give it out to the members, the locals, the employers. Everybody has it. And this process, which we've been talking about for 4 hours, is really hard, but it's what separates a union workplace from a non-union workplace. In a non-union workplace, the employers don't have to put up with any of this. They can just do whatever they want. And so you, by being on a bargaining committee, are really part of a long history of collective bargaining in the United States that started even really before the National Labor Relations Act, in your case, with that 1926 two-pager first Hollywood Basic Agreement. And I really thank you for being here. I always like to end these kinds of things with a quote. And this one I picked for this presentation. The only effective answer to organized greed is organized labor. Thomas Donahue was a past secretary treasurer of the AFL-CIO, but I really chose his quote because he was a doorman at Radio City Music Hall, which I frequently walk by in my daily life, and came from the rank and file and saw how necessary bargaining was to keeping work and safe and workers properly compensated for it.